Professor Sarikakis, who is going to chair this panel, and just welcome you all to this conference in Madrid. And let's start. Yeah.
Right. Thank you so much, and good morning from my side. What an honor to be among all of these women here and one online. So our panelists and organizers, incredible. And how am I supposed to even introduce them? Because each one of them deserves a conference of themselves. So just a couple of words I will say, and I think it would be a great deal for everybody here if you said a couple of words from your experience when you're giving your position statements, your interventions. But I will make a very kind of brief introduction. So we're discussing the role of case law this morning. First, disclaimer, I am not a lawyer. So for me personally, as social scientist, the law is many things, such as process, for example. For me, it embodies also ideological positions, but it does have very strong normative aspects, which is what we're discussing here. And as a social scientist, and this is an interdisciplinary conference, we would be very, very interested to hear not just the expertise of lawyers and attorneys and legal scholars, but also a little bit more about how something so sometimes understood as sterile or difficult to understand for the broader society has profound implications both for our political systems, our democracy at a large scale, as a large-scale human project, but also our everyday lives. We are going to be having some position statements, brief interventions from our speakers, and then we will continue with a conversation, and this conversation will be extended, of course, to you as well. I'm presenting our panelists in the order that is on your program, so just to keep things less complicated. And so Catherine Elena, correct?
Yes.
Yeah, please correct my pronunciation when necessary. Just a couple of words. Has experience in anti-corruption and matters of democratic trust. As a social scientist, this is what I focused on from your CV, and has been a special advisor to the Standing Committee on Electoral Law at the American Bar Association, among a million of other things that, of course, attest to her experience and professionalism and commitment to the topic. Ingrid Bicku, who is online. It would be nice if we could see her. Hi, good morning. Focused on electoral and communication issues, and currently her work is focusing on questions around marginalized groups. She is at the International Institute for Democracy and Electoral Assistance, International IDEA. Albertina Peterberg, expert in electoral law, also a huge CV, journalist and electoral expert and journalist working at the UNESCO Freedom of Expression, Security of Journalists section. Again, amazing expert with more than 20 years of experience in the areas of communications, elections, and women's political participation. She has been everywhere, almost where needed. I'm sure you're needed in many more places, but thank you for being an activist nomad for democracy. So she's been, I'm saying this because her CV says she's been in several missions in Niger and Ivory Coast, Tunisia, Libya, East Timor, New Caledonia, Mexico, Bolivia, Colombia, Ecuador, Dominican Republic, Venezuela, among others, okay? So I'll stop there. Wonderful. And last, but totally not least, is Anne Ravel. Ravel. I thought so, but
It
then I thought I
doesn't
should
matter.
Americanize it more. Okay. Ravel. Anne Miller Ravel. Or Ravel. So you ran for the Senate.
State Senate.
State Senate. This is the closest I've ever come to a U.S. Senate.
I didn't
State
win.
Senate politician. Well, the losses of the Senate, the State Senate. So, Anne Ravel, former commissioner, correct, for the Federal Election Commission, FEC. She was appointed by President Obama, I see here, in 2013, and by unanimous confirmation by the United States Senate, and she was chair of the commission for 2015 and vice chair in 2014, and then decided that enough is enough, right? And resigned in 2017 and became a professor at the University of California, Berkeley School of Law. We are so grateful to have you in academia full-time. So, thank you all for being here and for allowing me to make these semi-clumsy introductions of your amazing lives. I suggest we start with, in this order, to have your, if it's okay for you, to have a first round of interventions. And let's start with Catherine. And then we move on to Ingrid, who's joining us online, as we saw. So, floor is yours. 5 minutes, kind of.
Okay, I will try. Thank you so much for the introduction and to the organizers for the invitation to be here. I don't know if a panel of women was planned or just a very happy accident, but I'm very privileged to be among the women here. I am a lawyer, but I would say my caveat is I am not an academic. I am what I would call a practitioner. I'm currently the vice president of the International Foundation for Electoral Systems, and we work around the world with election commissions, judiciaries, civil society, basically strengthening electoral systems. And I'm here partly with the scientific committee of the Global Network on Electoral Justice, along with some very dear colleagues here and Anne as well. So I'm going to briefly, around 5 minutes, I will try, just touch on some of the case law that IFIS tracks in our work. As I said, we work around the world, so we are looking at some of the judgments coming out from a range of different courts and looking at the trends that we might see. Together with my colleague Tufane, we have established a database online of national election court judgments from around the world. It's called electionjudgments.org. So I wanted to just pull out a few cases relevant to the topic of disinformation and what are some of these judgments saying. I will say there's still a fairly limited case law specifically on disinformation, but there's starting to be a growing body of jurisprudence. There is some overlap, I think, of cases focused on the use of social media in elections, but not all of those are related to disinformation. There are quite a number of cases, for example, around the use of social media during the election silence period in many countries, cases around breaches of campaign advertising rules or campaign finance rules. But there are some cases that are starting to come out which are also touching specifically on disinformation. And one recent example, there's been some large elections recently came out from the Nepal Supreme Court from the 2022 elections. And there was a social media campaign called No Not Again campaign. It was started on social media by a group of voters. And it was aimed basically to encourage voters not to vote for the 6 main political parties. And part of that campaign had a range of not so true statements. So the Electoral Commission of Nepal basically fined the group, the voter group, and referred them to Nepal's Cyber Bureau to basically take down this campaign from social media. So had a ban on this campaign. So this writ petition was taken to the Supreme Court, and essentially this case revolved around, freedom of speech in elections. And the court ultimately issued an interim order not to ban this campaign until a full hearing was heard. So it upheld these voters' rights despite there being some disinformation considered in this campaign. So you can see the court is grappling here with this balance between the impact of disinformation and freedom of speech. One thing we are increasingly seeing are post-election cases that are challenging the legitimacy of the election result and using disinformation to do so. So the court here, of course, is becoming somewhat of an arbiter of fact or truth, where the petition itself may be rife with disinformation. One example of this was in the Kenya 2022 presidential election recently, and some of you may recall in 2017 the Kenyan presidential election was annulled for a range of reasons. Well, this time around, quite similar claims were made about the electoral process, that there was irregularities, that there was fraud in the electoral process, and again, the petition came to the Supreme Court. And here, the court ruled unanimously to uphold the election. And one of the holdings or findings said, not a single document has been presented by the first petitioner to prove systemic ballot stuffing, and that the Election Commission proffered a plausible explanation for the vote differential. It is a long judgment, this one, but the court spent a lot of time going point by point, basically countering some of the disinformation that was being put forward by the petitioners. So some of you may have seen recently in the news in the United States another type of case that has come about following the 2020 presidential elections. And this case was one of defamation brought by Dominion voting machines as an effort to combat disinformation. Now, this is not case law per se, because the parties settled at the last minute, $787 million payable from Fox News to Dominion, after the network basically alleged over and over again that Dominion rigged the presidential election against Donald Trump. So even though this was settled as opposed to decided by the court, there is testimony that's in the public record, which will be interesting to watch how future litigants will use this. And there is another voting machine vendor, Smartmatic, who is likely to use some of the statements from this in future cases. Even though defamation in the United States, there's a very high bar in proving actual malice in the case. But here the court said the evidence does not support that Fox conducted good faith, disinterested reporting. Evidence developed in the civil proceeding demonstrates that none of the statements relating to Dominion about the 2020 election are true. And these were accepted by Fox with no contest. So while it's a settlement, I think this will be an interesting precedent. One other trend I just want to touch on without taking too much time is the increasing use of the courts to sanction lawyers who are bringing cases based on false claims or disinformation. So this is another way that the court can potentially combat disinformation in elections. However, it's a tool that can only be used after the election, so after the disinformation has been taking place. In the US, there's a Rule 11 in the Federal Rules of Civil Procedure where a judge can sanction a lawyer for making false claims in litigation. And for the first time following the 2020 presidential elections, this was used several times. Once in Michigan, in King versus Whitmer, the district court sanctioned the lawyers by saying they made claims not backed by law or by evidence and failed to conduct an adequate pre-filing inquiry into the facts. The court quoted, "Circumstances suggest that this lawsuit was not about vindicating rights. Instead, it was about ensuring a preferred political candidate remained in the presidential seat, despite the decision of the nation's voters to unseat him." This, of course, was again about President Trump. So the court fined the attorneys and both a sanction and ordered them to pay the costs of the other party. Similar case happened in Colorado, where Rule 11 was used. There is one other set of rules in the US around lawyers' rules of professional conduct. And this was also used in 2020. Some of you, I'm sure, will know Rudy Giuliani from the news. He also was sanctioned by the Supreme Court of New York, which essentially debarred him under these rules of professional conduct for putting forward false and misleading claims. Two other countries where I've certainly seen this happening, one in Kenya, where they were sanctioned under the Advocates Act for bringing these cases or false claims related to elections. And then interesting one in Brazil, and I think we will be hearing from a colleague on Brazil later, where the court fined the parties in Bolsonaro's coalition 4.3 million for bad faith litigation following that election. So this will be an interesting trend to watch, and I think a tool for the judiciary, particularly with respect to post-election litigation that is seeking to delegitimize election results. My last comment, I think given judges' increasing role in elections, this of course makes judges and the courts themselves targets of disinformation and misinformation. Right now there is an ongoing petition against the presidential election in Nigeria, and there is misinformation already swirling in the news directed at the Chief Justice that he had a meeting with the successful presidential candidate in London, when in fact he travelled there for a medical procedure. So this is, of course, a trend. I wouldn't say a new trend, but targeting the judiciary, the credibility of judges and the judicial system to undercut the legitimacy, of course, of the judgments specifically around elections. I think there are things that judges and courts can do to try and combat the threats to the judiciary, but maybe we can come back to that in discussion, and I'll leave it there. Thank you.
Thank you so much. Thank you very much for that. The weaponization of information and disinformation seems to be expanding, and we see trends of that different spots of the world. Let's continue further now with Ingrid Biku. Ingrid, are you ready?
Yes, it's here. Yeah.
Good. Yeah.
Hope you can hear me.
Okay.
Great. I will just now try to share the screen with you. Because I'll try to be brief, of course, but I'm not sure to what extent I will manage. So do stop me when the case is. I have a presentation because just to mention that I was seconded to International IDEA for the last 4 years. I have now transitioned to a consultancy, so now I'm not necessarily representing IDEA, but I do plan to present the findings of the research that we've done there in the field of disinformation. And being such a broad topic, we have narrowed it down to the way it affects elections from the perspective of electoral processes, electoral institutions, and electoral officials. Of course, all the findings were interesting, but what we identify is the existence and the development of serious attacks against electoral officials worldwide, with different tactics targeting women and in a disproportionate way. So I must say that for a personal reason as well, being a almost former, let's say, electoral official myself and being targeted in the online space, I felt the need of raising the awareness on what is happening, especially because in many cases we have found that these attacks are initiated or disseminated by political figures or media domestically. Of course, difficult to establish whether there are foreign implications or who are the moral authors, but at least on the surface, it seems that the domestic political figures have an important contribution, let's say. So I will take you briefly through the general findings, and I'm hoping that in the discussion session I will be able to share more on the specifics of the disinformation targeting women electoral officials, but electoral officials in general as well, because men tend to be attacked a lot as well, just that it's different the way they face these attacks. Keep calm and carry on. Researching was the approach we had, myself and other women in electoral management who were targeted by these kind of attacks, and then it was a joke between us on what do girls do when they are attacked in the online space, and we're like, keep calm and carry on researching, which is what we did, and we ended up having this I would say the first evidence based on the cases of disinformation targeting elections in terms of the procedures and also targeting individuals. These are some of the questions that we have tried to answer through the research. It is a global research. International Institute for Democracy and Electoral Assistance is an intergovernmental organization with 34 member states aiming at supporting sustainable democracy worldwide. So by fortune, we also have IDEA, International IDEA has and is represented and works all over the world, which gave us a great provided us with the possibility of having a good perspective on how things are happening and how these attacks are happening in many countries, probably 53, exactly 53 countries. So some of the findings, the trend is going up, obviously. The cases of disinformation targeting elections are increasing from one year to another, and of course they tend to peak in electoral years. And you can see this in 2019, and we're actually expecting some serious issues in 2024. The organizations that were targeted by this information related to elections are mainly electoral management bodies, but of course also international organizations, NGOs, IGOs, International IDEA, IFAS, Carter Center, and many others were also targeted, and separately individuals representing those organizations as well. I should explain why individuals are why this percentage emerged in the case of individuals. It's because in the online space, at least, the perpetrators were very creative, and there are these ways of hiding the malign intentions behind disinformation. We call them well, actually, there are different ways of doing it, whether through hiding under temporary posts or making it impossible for fact checkers to identify whether it is disinformation, or other types of harmful content and conduct that go beyond disinformation but are at least equally damaging. I was saying that we don't only speak about disinformation, but a wide range of other types of aggression, discrimination, hate speech, humiliation, trolling, doxing, whatever you can think of. This is what happens to electoral officials as well, and it happens to women in a different way. This is one infographic that I like a lot because it shows the way disinformation, the attacks disinformation attacks against elections are being initiated across the electoral cycle, as well as which are the faces and the processes that are mostly targeted by disinformation. I won't insist on that, but I'm happy to share the link with you to this report. Now, a very interesting and relevant aspect from the perspective of regulation and enforceability is related to the initiators, because of course, in most of the cases, unspecified social media users were initiators or perpetrators of disinformation. But in many cases as well, on a closer look at their profiles, you could notice that they have a certain political affiliation, or at least an ideological one. And of course, political figures and electoral competitors is one category that I really need to emphasize, and that makes a lot of difference when it comes to then developing regulation, implementing it for protecting electoral management bodies and electoral officials against disinformation. Because one of the challenges, and my colleague Alberta Guevara will speak about this later today, one of the challenges in developing and implementing regulation is political will, also correlated with biases, traditional biases, and perceptions related to women and their role in societies. This is one important aspect that we have found. The dynamic, this is one survey in parallel to our research in 53 countries. We had, I would say, about 260, if I'm not wrong, electoral officials all over the world who answered our survey on whether they have or have not been targeted by disinformation. And you can see here the result. Obviously, the majority have been targeted by disinformation. In general, more women than men, but they are close anyways. I was telling you about the disguise techniques, those ephemeral posts, the temporary stories, for example, but also the malign euphemistic content that eludes detection. And in this case, is the disguise of the text in order to pretend that this is nothing harmful, which on the contrary, of course, is. And then also very much correlated with the regulatory frameworks is the lack of punitive consequences that correlated, of course, with the features of the online platforms which enable anonymity, that encourage the increase of these attacks in terms of numbers and aggressiveness. I do have to mention that anonymity has its benefits, particularly for communities in sensitive political contexts, which can express themselves and engage in democratic activity in the online space, despite the risks, overcoming the risk that they would have to face in case they would want to participate physically. When it comes to the impact goes on various layers, let's say, from perception to behavior. Sometimes it stops somewhere in between. But in many cases, it ends up with, it results in electoral violence, and when it comes to electoral officials, intimidation, aggression, different other types of malign behaviors that affect both the individuals on a personal level, but the institutions they are representing, and eventually they represent a threat to democracy. Here are some quotes from, I have interviewed already so far about, I would say, more than 25 electoral officials related to the strategies that they have identified when they were targeted by disinformation. I must say it was a very sensitive and difficult task, because in many cases we ended up crying together. It was one of the reasons why I felt the need of raising the awareness on these practices, but also the importance of the impact on a professional level and also on the institutional level, because these probably might sound not very familiar to some of you, but to some other of the colleagues here who are very much connected to electoral officials in high visibility positions all over the world. They are aware on the aggression that they have felt, and they are also aware, we are aware, on their decisions of eventually stepping back, resigning, which in turn means that these positions end up being occupied by people who are somehow willing to respond to certain influences, which are not always democratic and in many cases serve undemocratic agendas. I insisted a lot on the perpetrators and on the importance of remembering that political actors tend to be among the top perpetrators, because in the interviews it emerged that legal action was not a measure that was considered by electoral officials or by electoral management bodies as a way of protecting themselves against these attacks, precisely because they considered that they would never get the proper protection from a legal point of view. In some other cases, we had electoral officials saying that they did request legal support and they never even got an answer, or their file was buried among or under thousands of other files. These are some conclusions, but I think I should stop now. I keep looking at the clock to make sure that I didn't take too much time. The main challenge in terms of regulatory measures related to protecting elections in the information space has to do with balancing the freedom of expression with these measures. But then there are also many other challenges related to the dynamics of the technological environment, and then it's also the enforceability, because I was mentioning all these features, the global nature of internet, and all those features that the online space comes with, and it tends to make very difficult enforcing such regulation. Of course, we've seen codes of conduct and soft legislation, soft law, as an alternative that worked in some countries, but I must say that in some others, where gentleman agreement, let's say, doesn't weigh so much, these approaches didn't necessarily make a difference, but the simple fact of discussing about the issues at least raised the awareness amongst the audiences. I will stop here for now, but I will be happy to answer any question later.
Thank you so much. Thank you. Thank you, Ingrid. And without further ado, we're going to Albertina Peterbach. Very exciting conversation till now. Please, Albertina, take us further.
Hello. Yes, it's fine. Thank you very much for inviting UNESCO and inviting me to represent UNESCO in this conference. I'm very honored, and I'm also very honored of being part of this panel. Yesterday, we talked a lot about opportunities and the challenges of the new digital era. We addressed the issue of disinformation and hate speech being widely disseminated throughout different platforms worldwide, and how these challenges affected democratic institutions and electoral processes. We also discussed transnational disinformation campaigns, and we mentioned the challenge of multilingualism. Not all disinformation campaigns are run in English, Spanish, Portuguese, Bahasa Indonesia, big spoken languages. Many of them are run in local languages and dialects, and that makes them very, very difficult to detect and to tackle. We also discuss how children and teenagers who are future voters and citizens are manipulated, affected, and disinformed through toxic contents. We also mentioned the difficulty in coordinating coherently with platforms at national, regional, and international level, and the immense power they have in deciding how to regulate themselves, their lack of transparency, the huge legal loopholes that allow them to go fast, to run fast and unrule, and the immense challenges that all this reality means for democratic states. Today, I will present a brief overview of UNESCO's global project for safeguarding freedom of expression and access to information in the shape of guidelines for regulating digital platforms. This is an international endeavor aiming at serving as a resource for policymakers, regulators, and platforms, civil society, and a wide range of stakeholders. So, I don't know where.
You can use this.
Okay.
You can use this.
Enter.
Enter.
Okay. Okay. Thank you. Okay. Fine. The version 2.0 of the guidelines was discussed at the global conference Internet for Trust that took place in Paris on the 21, 22, and 23rd February this year. The event counted with more than 4,000 participants, and 1,000 of them attended in person, and UNESCO received hundreds of comments and very active feedback from many stakeholders, including the Complutense University of Madrid, so thank you very much. For reference, this is how the version 2.0 of the guidelines look like. Now it has changed. You can find the new version at Internet for Trust section in the UNESCO website for your reference. So, but what is the objective of the guidelines and why is UNESCO leading this global process? The aim of, as I mentioned before, the aim of the guidelines is to safeguard freedom of expression, access to information, and other human rights in the context of the development and implementation of digital platform regulatory processes. Of course, the guidelines are calling the states always worldwide to apply regulation in a manner that is consistent with international human rights standards, including with the Article 19 of the International Covenant on Civil and Political Rights. But why UNESCO? As I mentioned before, UNESCO is leading this process because UNESCO was created in 1945 with a global mandate to promote and secure the free flow of ideas by word and image. Over the decades, UNESCO has implemented different initiatives to tackle the problem of disinformation, misinformation, and hate speech offline. It means real life, before this digital era. But as we all know, during the last 2 decades, the situation has changed dramatically. UNESCO initiatives have also evolved to approach the problem, acknowledging that the scale and impact of these issues require more tools and new efforts from every sector of the organization. Therefore, from education to social science, environment, gender, and communication and information, there has been intersectoral work to put forward a comprehensive solution to tackle the problem. Specifically, the UNESCO Communication Information sector, I'm part of this sector, has worked in recent years on promoting media and information literacy skills, supporting media viability, and working to build societal resilience to harmful content through a range of partnerships and collaborations. To develop these guidelines, UNESCO commissioned a study conducted by the Research ICT Africa that reviewed more than 800 academic, civil society, journalistic, and corporate documents to produce a paper on digital governance and the challenges for trust and safety that you can also find in our website. The study indicated growing evidence that harms to human rights, both directly online and with offline impact, are associated with gaps in the broader existing national and international regulatory regimes within which these companies operate. False and misleading content on the platform is widely perceived as a significant threat to democracy in general and elections in particular. As I mentioned before, consultations have passed throughout different stages since September 2022. The last stage will close in June 2023, and the final document of the guidelines will be published by the last quarter of this year, so still is time to give your feedback. Who are these guidelines for? The idea of the guidelines is to serve as a resource for a range of stakeholders, policymakers in identifying legitimate objectives, human rights principles, and inclusive and participatory processes that could be considered in policymaking, for regulatory bodies dealing with the implementation of regulation, for digital platforms in their policies and practices, and for other stakeholders such as civil society organizations in their advocacy and accountability efforts. All stakeholders share responsibility for sustaining and enabling environment for freedom of expression and the right of information, while ensuring there is an open, safe, and secure environment for users and non-users, particularly the most vulnerable ones. Regarding the implementation parameters, UNESCO considers this as a living document subjected to periodical reviews and updates. About the scope of the guidelines, version 3.0 outlines that the scope of the guidelines understands digital platform, and this is very important, as companies that provide user-to-user services, as internet services, which allows users to generate, upload, and share content online, and this includes social media platforms, dating applications, games with chats, and forums, including where users can interact in direct messaging. Search services, which allow users to search multiple websites or databases. We also consider as a global platform internal business services, network infrastructure such as ISPs and VPNs, and business-to-business services, emails, voice-only calls, and SMS and MMS. Open access, open science, and open educational resources are also considered as part of this platform concept. And while regulatory requirements and enforcement such as those proposed in the guidelines should be stronger in the case of large platforms, particularly market-dominant ones, it is important to know that all platforms from all sizes need to commit to the full respect of international human rights law. The guidelines describe the responsibilities and principles for digital platforms to respect human rights with 5 key principles. Platforms need to conduct human rights due diligence, evaluating the risk and impact on human rights of their policies and practices, as well as defining the mitigation measures. Platforms should adhere to the UN guiding principles of business and human rights, including in platform design, content moderation, and curation. And platforms need to be transparent, open about how they operate, with understandable and auditable policies, as well as multi-stakeholder agree metrics for evaluating their performance. Platforms should make information and tools available for users for them to understand and make informed decisions about the digital services that they use. As the document's objective is to serve as a resource for a range of stakeholders for regulating, regulatory bodies are critical to this endeavor. Obviously, there are different types of bodies involved in online regulation worldwide. Some regulators exist independently of the government, while others are constituted as government agencies. This is also true for electoral regulatory bodies and electoral management bodies. Recognizing this complexity and the complexity of this environment, the guidelines are meant to be useful to any system of independent regulation, irrespective of its specific modalities, and accept that local context will impact on how regulation is enacted and implemented, particularly during elections. In this regard, and I will finish with this, the guidelines have a section dedicated to specific measures for the integrity of elections. They present as a first and basic step a very obvious thing, but that is not so obvious when we look at reality and the reality we've been addressing this morning. The first step should be that the fact that digital platforms must acknowledge the importance of contributing to democratic institutions and to the preservation of electoral integrity. For that, the guidelines indicate that digital platforms should have a specific risk management process addressing the integrity of the electoral cycle for major national election events, significant regional elections, or major referendums. Such risk assessments, of course, should also consider the users, the level of influence that advertisement messages may have on them, and the potential harm that they may come out of such messages if used against specific groups, such as minority and other vulnerable groups. These assessments that are recommended by the guidelines must be transparent and coherent with human rights due diligence and should be executed by engaging all relevant electoral stakeholders. Also, this assessment should be conducted before, of course, electoral events to implement concrete measures to mitigate the identified risks. Within the assessment, digital platforms should review whether their products, policies, and practices infringe human rights and or amplify content that can be restricted under international human rights law, or whether political messages that deliberately undermine the confidence of voters in the electoral process are being transmitted. Digital platforms should also engage with the regulatory system and relevant civil society groups prior and during elections to establish a means of communications if concerns are raised by the administrator or by users and voters and concrete action is needed. These red lines are really lacking in many big countries too, not only in small countries or regional and national level or local level for elections. And sometimes in many countries where the platforms are not even present, there is not such a type of communication prior elections or during elections. The platforms need to accept advertising designed to impact the political process should clearly be identified. Context, we mentioned that this yesterday too, the myriad of contents that are not obviously part of a political campaign or contributing to a political campaign, but influence a political campaign. They should ensure that the platform should ensure that funding and the entity that is funding are identified and consistently apply equal content moderation and curation rules on political advertisement for all political players and at all national and worldwide. That means that it cannot be possible that platforms negotiate type of rules and regulations in a country and then do a totally different thing in a country in another country. So that's the idea. Information, of course, another important thing is that we mentioned yesterday too was follow the money. Expenditures on advertising and promotions by political parties and individuals representing political parties as well as social media promoters should be transparent and available. So in this sense, platforms should disclose to public information and through specific demographics and advertising promotions. That means micro-targeting also need to be transparent. So to end, the platform should retain these advertisements for archive. And this is it. Sorry if it took too much time. Thank you very much.
Thank you. Thank you. And may I invite Anne to give us her intervention? We are going to take a few minutes from the break, by the way. so we have a little bit more
Thank
time
you.
to have a meaningful conversation. Thank you.
Thank you very much. And since I'm a lawyer, I follow the rules. So, so I'm going to talk about disinformation control in the courts, in particular in the United States. But I want to mention that I have done a lot of electoral work, both in Mexico as well as in Brazil, and they have electoral courts, including electoral Supreme Courts, which is a very good thing to have, that I think makes them much more adept than in the United States at dealing with a lot of these issues of disinformation. In fact, the United States, it's extremely complicated because of the United States Supreme Court, the issue of how to deal with disinformation in the courts, because, and I'm going to follow on a little bit about what Catherine talked about, but the United States Supreme Court has interpreted the First Amendment, which is the right of free speech, very, very broadly. Disinformation in many situations, which was rampant in the United States, both in 2016, when there was Russian intervention and false tweets and Facebook pages that was paid for by Russia. Nonetheless, there has never been any rulings by either the Supreme Court or any other courts with regard to that kind of intervention, both by Russia and also by, of course, American actors as well, because the Supreme Court has ruled that false statements and hyperbole are inevitable in a free debate. And so the court has indicated that the government itself cannot regulate false ideas, false factual statements generally, also receive constitutional protection in the United States. So it is very difficult to regulate false speech, which would be then unconstitutional, unless the government can show two things: that the challenged law is the least restrictive means of targeting speech, and also has to serve a compelling government interest, which they've never been able to do this at all in the United States in the court decisions. But there are several exceptions. One of them is about defamation, which Catherine spoke about a little bit because of the Dominion case that she mentioned, where it was very clear that Fox News was making up things about the Dominion voting machines and claiming that they were switching votes from Trump to Biden, which had absolutely no basis in reality, and Fox News admitted it, which was what led to the large settlement that they reached that Catherine mentioned, because Fox couldn't say otherwise. They clearly were lying about the fraudulent nature of those voting machines. And that is one particularly clear way that the courts can, and could have. And in the case there, it was a Superior Court judge who also said, and turned to Fox News and said, this was all lies. Everything you did was lies. And so for that reason, they agreed to that big settlement. It doesn't matter though, because people are continuing to claim that there was election fraud in the United States and that the machines, it's kind of very similar, the Trump allegations as well as Bolsonaro's allegations at the same time about the fraudulent election machines, of which there is absolutely no evidence in the United States for this, but it is nonetheless still continuing as a large group of people who still believe in this. So the other exception to what can be regulated in the United States with respect to the electoral process, not so much about, I mean, we can get into the money in politics as well, which is regulated, but the other basis for regulation are statements that relate to voting eligibility of potential voters and statements about where and how to vote, because there's a lot of, particularly in 2020 election in the United States as well as 2016, there were a lot of false statements about how to vote and where the voting places were. For example, there were lots of statements on social media claiming that you could vote by text, which is, of course, not true. And so it is definitely not legal. And many of the other statements that have been made that were false had to do with the impairment of citizens' ability to vote, as well as in a number of states where there have been false ballots that were procured that were found illegal, and other ways of preventing voting. And one of the issues that is not exactly related to disinformation, but in the United States, the courts, in fact, and the U.S. Supreme Court have struck down provisions of the Voting Rights Act, which was enacted essentially in order to prevent discrimination, primarily against African Americans, also against Latinos and others, to prevent them from voting. And the Supreme Court nonetheless struck it down, the provision that had required a lot of states that had spent a lot of time discriminating against those people and not allowing them to vote. And so there was something called the article of the Voting Rights Act required preclearance, that those particular states had to agree or show that they were no longer going to discriminate, that they were going to actually behave properly, but the court struck down that preclearance requirement. And this is an issue that is really problematic now in the United States, because much of what has occurred during the last few electoral processes was essentially attempts by states to suppress the vote, and particularly to suppress the vote against minorities, suppress the vote against young people, because they have voter identification requirements, that a lot of students are going to colleges in different places or going to be in different places, and they themselves are then incapable or unable to vote. And that is what I would say now a much more concerning issue in many ways than some of the disinformation that has also been rampant. But a lot of this also emanates out of the disinformation that you can see on the platforms. And it was interesting to hear about the attempts to regulate the platforms, because the United States Congress has never been able to actually get together and find some way to regulate platforms and to demand that they do some of the things that you mentioned, that UNESCO has suggested that they do. And, you know, unfortunately, I think it is a complicated problem. I happen to live in Silicon Valley, not too far from Facebook, not too far from Google, and I've got a lot of neighbors that work in those places, and it's quite difficult given the number of postings that they have and the difficulty that they have in kind of doing something that's going to prevent this kind of behavior, and some of the vitriol in particular, and the aggression that is now seen here that was also mentioned against voting authorities in the United States. It's a hugely problematic issue. So I know they learned it though from Russia. That's how to try to make sure people didn't vote, and that is true, because in 2016, Russia had over 10,000 tweets and posts on Twitter telling Black Americans not to vote. Don't vote for Hillary Clinton, vote for Trump, don't vote because she's a racist. And they had false, on Facebook, false groups one of them was called Blacktivist, which some of you may know about Black Lives Matter in the United States, which is one of the biggest groups that is working with African Americans to support that they are subject to a lot of harassment and a lot of other terrible things that happen to them. But Blacktivist was made up by Russia, and it had far more people looking at it and seeing some of the false statements during the elections in both 2016 and 2020 than the actual true Black Lives Matters had. And so it had another huge impact on essentially voter suppression in the United States. In terms of the courts now also, the issues that they look at mostly with regard to elections have to do with voting districts, and it is a big problem in the United States with regard to establishing districts locally that will also suppress the vote and make it more difficult for certain people to vote or certain people to be able to win. And this is a long history in the United States of discrimination against Black Americans, and it's continuing through what's called gerrymandering there to gerrymander districts so that they are either more Republican or more Democratic, or also districts that will give less power to young people, young voters, and minority voters. So those are the biggest issues that are facing the courts now. And there's been some cases related to this about whether the local governments, the state governments have power to oversee these things, or whether it is the federal courts and the federal government that has the right to do that. And it's still up in the air. There's a case now that came out of North Carolina, but it's those are the major issues, and there is so much to talk about the problems in the United States. I could go on for hours, but I won't, I promise. So I think that those are the major issues that are court-related issues and electoral issues that we're now facing.
Thank
Thank
you.
you.
Thank you very, very much. I think we can open the floor for questions. And just as a reminder, if you can again identify yourselves.
Oh, yeah.
Thank you.
Thank you. Rodrigo Cetina from Universidad Pompeu Fabra. So we just heard Ingrid talk about harassment of women and the panel in general in elections. And then in the case of the United States, we were talking about court issues, no? Well, I guess breaking news from last night to today, there's another defamation suit against Fox News. This time Nina Jankovic, who's actually a researcher, on specialist on Russian disinformation. And she claims that things that were said about her on Fox News especially, in this case, led to her being harassed and defamed online. And she actually went to the same court in Delaware that Dominion voting went to and sued Fox News. So I think I would like to hear, I guess, Anne, this will be for you since we're talking about the United States, but your take, because it's a little bit different, no? Like, Dominion voting system, it was a defamation suit. There's also 2 shareholder suits against Fox News itself. But this is different, one, because it's first and very important, a woman claiming her safety was put into question, or she was under threat because of disinformation and defamation, not exactly the same thing, but in this case, related. But also because it's an individual in this case. It's not a company, no? So
Right.
defamation is going to have some. Yeah, I would just like to hear you.
Yeah, defamation does apply to individuals, and clearly, and so especially if you can show that it was defamation that was done with malice, and that it can impact that person's reputation, which is what actually Dominion said, that it was concerning their reputation, and in this case that you're talking about, it's also the same. And so those cases are singular cases that can succeed, and in this case could succeed, certainly. If it could, definitely, it could. And obviously the court is now primed for it.
Thank you. More
Yes.
questions? Yes. please.
Hello. I'm Oscar Sanchez from the University of Valladolid and the Venice Commission. And my question is about the legal argumentation in disinformation cases. When a court is going to restrain political free speech, we need a very good reason to do so. We need a very compelling interest, as you have said. Therefore, I think the question about the constitutional ground in these cases is a crucial one. And we have different options in choosing constitutional grounds in the claims, no? So, for example, we choose the protection of the integrity of the election, I think we enter in a very dangerous path, because we need to prove the harm that has been done. And this is not easy to do. And moreover, the harm, usually we can only see what is the harm that has been done after the election, not before. No? We have another option, is the protection of truth. And in this case, we enter also a very dangerous path, because we force the court to decide about what is false, what is true, about the truth or the lies. And I think this is not a good solution either. No? So what is the possible constitutional ground, the possible compelling interest? I think, in my opinion, I think we can use a similar argument as we use in the political finance cases. So it's, in my opinion, the central issue is how some dissemination techniques are affecting the equality of opportunities among between the electoral competitors, and how these techniques allow some of the competitors or other actors to exert an undue influence over the electorate. In some, I think this is a very similar ground as the ground used in political finance cases. It's we agree, in fact, that there are some weapons that cannot be used in elections. But the problem is we can use this kind of argument in Europe or perhaps in Latin American countries, but not in the US because of the Buckley versus Value and Citizens United doctrine of the Supreme Court. So what do you think about this question of the argumentation?
You go
That's
first, and then I'll go.
Yeah. Well, you're right about campaign finance and the difficulty to enforce the law with respect to that in the United States because of some of the case law that has occurred that permits almost unlimited amounts of money. The violations that are clear violations are things like Donald Trump giving a lot of money to Stormy Daniels, the prostitute, to cover up for his electoral process. But even that has been a little difficult to enforce in the United States. So, I mean, I do agree that in the court system in the United States that it's much less likely that many of these other that you wouldn't use the campaign finance regulations and enforcement to compare to the electoral issues that are a concern in terms of the truth.
Yeah, it's an interesting suggestion, and I think the first question that comes to my mind about, having this criteria of whether disinformation is kind of disrupting or affecting competition or the playing field, I think I would then to start think about what type of evidence is the court going to require to be able to prove that competition has actually been affected. And then my next question would be, if that bar could be met, then what the remedy might be for that. But I think it's an interesting conversation to have. I will say I probably feel differently about the role of the courts. I do think they play an important role in terms of being arbiters of truth. I mean, that is what they're there for, and I think we're seeing that more and more in elections. And a lot of countries are now relying on the courts basically to resolve these significant electoral disputes. So I think we have to understand the limitations of the courts, the regulation that's at their disposal to be able to tackle disinformation. But I do think being able to cut through the disinformation to rule on the facts of the credibility of an election result is incredibly important. And then I increasingly think the role of the courts in controlling the, and it's particularly the US, I guess, but the legal profession and how the legal profession is itself contributing to disinformation, I think is an important trend.
Thank you. Yes.
Hello. Yeah. Good morning. I'm José Luis Vargas. I'm Justice of Electoral Tribunal in Mexico. I'd like to ask to give a comment and a question to Ms. Albertina, and it's because I had the opportunity to be in February in the meeting of UNESCO, and I think it was a great meeting. But in my opinion, I mean, it's good to have this effort to do a code of good practices, a guideline, but it's not enough. And the question is if you think it shouldn't be raised, this problem, not to in the UN, to the to other level of finding a solution for misinformation, because it's not anymore a a cultural or a educational problem. It's a security problem. I mean, what we are dealing is the capability of some agents in industry that has the capability to affect democracies. In other words, we just talked about Cambridge Analytica. These days, we just talked about many of the issues that we are facing. So this problem could finish in a war. It's already we're already having this kind of problems. So I think we need to have legal instruments that can bind the actors, and especially the industry. So has that been discussed in the UN, and why it keeps in this level? Thank you.
Thank you very much for the question. Two different things. As you know, the UN works through different agencies and funds, and each one of us, me as representing UNESCO, we have different mandates, and usually we try to get coordinated and not to overlap these mandates and to have coordination. Of course, these guidelines are related to UNESCO's mandate and are related to the protection of freedom of expression and access to information, the security, safety of journalists, and the role of the journalism, and of course also the integrity of elections from the point of view of access to information for voters. So it's circumscribed to these guidelines are for regulating platforms, and this is circumscribed to this issue. It doesn't mean that UN is not addressing other issues, as we know that disinformation impacts on reality, as it happened in United States or in Brazil recently, and that can have a real impact on electoral-related conflict and electoral-related violence, and we are working in this in coordination with other agencies. It's not that UN is not addressing the issue, it's just that this document in particular is it's addressing a specific topic. But this is part of a whole discussion that's taking place in the United Nations regarding how to prevent conflict related to the dissemination of information online and offline, of course. In the case of elections, because this is the subject of this conference, we are working together with the other organizations, most particularly with the PKO, which is Peacekeeping Operations, the Department of Peace and Conflict Prevention in the Secretariat, and they are also coordinating the actions of different agencies, because we have also, and regarding violence, as I said before, we have terrible issues that are related to human rights violations that are happening in different languages, and multilingualism, even if it's not the main topic of our conference, it's a huge challenge. Because most of human trafficking, for instance, in sub-Saharan region is happening in Hausa or other local languages. So we are discussing this at another level. These guidelines that I presented today are restricted to what I presented, that is to guide how to deal with platforms.
Ingrid would like to also intervene. Can we maybe have your screen on, your camera on, Ingrid, so we can.
Thank you. If you don't mind, I would keep it off.
Okay,
because I have another commitment now at 12, and I had to kind of run. So I've connected from the phone now. I think it was a very important point that was made previously on the delimitation between the types of threats and to what extent cyber and cyber-enabled threats are considered a threat to national security or to international world order. I remember some very interesting, and actually I must say that I think at every Riga Stratcom dialogue, which is organized by the NATO Center of Excellence on communication, strategic communications in Riga. Always, I think every year the question was, what would be something that would determine the activation of Article 5? what kind of threat, what is the criteria, what kind of attack in the cyberspace or enabled by the cyber technology would be able to generate such a decision. And of course, the answer was never clear, I must say. On the other hand, disinformation was part of the hybrid threats that have been used in conflicts for years. And I think, and I think it was mentioned before that reconciling the two would probably be a work that I think is emerging a lot now as a topic, and it relates a lot to to digital diplomacy. So I'm not sure if this topic is being addressed at some level in relation to disinformation in the field of elections, or disinformation and other harmful conduct or content in the online space. But I believe that more and more importance is gaining these discussions that as colleagues said, are happening at a different level. And I wonder to what extent are elections practitioners or relevant stakeholders in the elections field and in other fields also involved in those discussions. Thank you. That was my intervention. I hope it was not too long.
Thank you very much. And with this, may I take the opportunity to thank everyone, and of course our wonderful panelists, Anne Ravel, Albertina Peterbach, Ingrid Biku, and Catherine Elena. And also thank you to Loreto, of course, and the main organizers of this conference. Let's continue our conversations out there. And I'm giving you a question for out there, which is, how do we reconcile the local character or national character that elections have, courts have, with these global challenges, right? Which would go, it seems to me, it would need more than guidelines and principles, but something with teeth. All right, so thank you so much. Anything else for? No, we're good. I had so many questions written down for
Hay un streaming, lo que pasa es que originalmente esta no la transmitíamos, entonces no creo que nadie esté en el enlace, pero está en YouTube. O sea, hemos cambiado porque como se transmite se graba.
Bom dia a todos. Nós teremos essa mesa, que será uma mesa em português. A gente vai tratar hoje sobre a questão da desinformação no processo eleitoral brasileiro, que é um tema de interesse de várias pessoas, de vários países, e que vem sendo desenvolvido com bastante determinação pelo Observatório Complutense e Desinformação. Então, um dos casos que a gente vem tratando nas nossas pesquisas e que hoje vão ter a oportunidade de falar com grandes conhecedores do processo eleitoral brasileiro e que trabalham também com essa temática nas suas investigações. Então, sem mais delongas, porque a gente quer mesmo ouvi-los, a gente vai tratar, então, inicialmente, da mesa que trata sobre eleições brasileiras, desafios e oportunidades, iniciativas que foram desenvolvidas no processo eleitoral. Vamos iniciar os trabalhos, então, muito honrados com o professor Rafa Rubio em nossa mesa.
Vitor, desculpa, perdão. Seu microfone está desligado para a gravação.
Ah, está desligado?
Perdão.
Obrigado. Vamos iniciar nossos trabalhos hoje com uma palestra do professor Rafa Rubio. O professor Rafa Rubio é catedrático de Direito da Universidade Complutense de Madrid, doutor em Direito pela Universidade Complutense de Madrid, membro da Comissão de Veneza, co-diretor do Observatório Complutense de Desinformação e do Grupo de Pesquisa, Tecnologia y Democracia. Profesor Rafa, con la palabra.
Muchas gracias, Víctor. Bueno, yo voy a hablar en español por motivos obvios, que es que no soy capaz de hablar en portugués, aunque he trabajado en distintas ocasiones en Brasil. Pero además de la dificultad del idioma, esta intervención tiene una nueva dificultad, que es hablar delante de los protagonistas del proceso, de alguna manera, o de personas que han desempeñado un papel relevante durante el proceso, específicamente en esta materia de la desinformación. Esta dificultad me sirve como para poner en valor, yo creo, esta mesa, porque de alguna manera vamos a hablar desde un punto de vista tremendamente práctico de un problema que, más allá de todas las dificultades teóricas que ofrece y que hemos podido ir viendo durante estas sesiones, donde se han puesto sobre la mesa desde distintos prismas las dificultades de la lucha contra la desinformación en periodos electorales, pero la realidad es que cuando se afronta el problema en un caso concreto vemos que hay un problema práctico muy, muy evidente, y al final es en esa puesta en práctica de las soluciones donde nos jugamos, o donde se juega la eficacia de las respuestas. Por eso creo que es una gran oportunidad poder contar con este panel. Y a mí a veces me ha pasado, seguro que a todos ustedes también, que hay veces que hablan de lo que ustedes han hecho y uno ni se reconoce, ¿no? O sea, dice, ¿y esto lo he hecho yo? O sea, como saben algunos, he trabajado mucho haciendo campañas electorales online, y he leído muchos artículos sobre las campañas electorales online que yo había hecho, y yo siempre decía, joder, pero yo no he hecho eso. Pero se interpretaba de una forma absolutamente... Entonces, no quiero caer en el mismo problema, ¿no? Decirles a las personas que me rodean, que han tenido un papel activo, tanto desde el punto de vista de la sociedad civil como desde el punto de vista de las autoridades electorales, qué hicieron. Y por eso voy a tratar de construir o de explicar o poner en contexto esas elecciones, y solo al final me permitiré una valoración general, insisto, desde fuera, de lo que sucedió. Pero para ponernos en contexto, o sea, Brasil es un país en el que 165 millones de personas tienen acceso a las redes sociales, para ir poniéndonos en contexto. Es el quinto país con más usuarios de redes sociales del mundo. Además, es un país donde, como saben, las elecciones se venían celebrando desde hace más de 30 años a través del voto electrónico, sin grandes dificultades y con una eficacia probada. Para que se hagan una idea, en la primera vuelta, esto es casi, me imagino, yo al menos no soy capaz de calcularlo, pero se emitieron alrededor de 600 millones de votos, porque se celebraron a la vez 5 procesos electorales. O sea, insisto, esto es un cálculo muy grosso, pero creo que más o menos, al menos más de 500 millones, podríamos decir que es real. Y además fueron recontados, esto para poner sobre la mesa la eficacia, en un plazo de en torno a las 5 horas, quizá un poco menos, pero a las 4 horas teníamos el 90 y mucho del voto recontado sobre el total, lo que me parece, o sea, lo que da una idea de la dimensión de lo que estamos hablando. No ya solo desde el punto de vista de la desinformación, que es lo que ponía de manifiesto con los 185 millones conectados a las redes, sino también del volumen del proceso electoral en sí mismo y, por tanto, de las dificultades que tiene pues tanto su organización como su defensa en términos de legitimidad del mismo, ¿no? Por seguir poniendo contexto y dejarles a ellos que hablen del hecho concreto, me parece que uno de los grandes aciertos de la actuación de las autoridades electorales brasileñas en esta materia es que supieron aprender del pasado. No sé cómo decirlo. O sea, Brasil ya en el año 2018, como todos saben, había tenido un problema claro con la desinformación, un problema que se había resuelto en términos jurisdiccionales de una forma, en mi opinión, discutible, sobre todo en lo vinculado a la redistribución de mensajes a través de WhatsApp, la compra de esas bases de datos, o sea, que era un tema tremendamente complejo y que, en mi opinión, se resolvió de una forma, bueno, a posteriori y complicada. Pero de esa experiencia del año 2018, que se complementa con la experiencia del año 2020, creo que hay un mensaje positivo, que es que las autoridades electorales entienden la dimensión del problema y asumen la necesidad de dar una respuesta y dar una respuesta en términos estructurales y mantenidos en el tiempo. O sea, que resultaba absolutamente inútil, y esto es una cosa que muchos organismos electorales a día de hoy siguen sin entender, tratar de resolver el problema en el proceso electoral. Que la desinformación es un problema que desborda el proceso electoral y que cuando tratas de dar respuesta de una forma puramente reactiva durante el proceso electoral ya no tienes capacidad de respuesta, porque la estructura, cuando hablamos de campañas organizadas y estructuradas, está organizada y montada desde hace mucho más tiempo y, por tanto, juegas en inferioridad de condiciones hasta el punto de hacer tu respuesta inútil, por decirlo de alguna manera, ¿no? Entonces, en ese contexto, y este sería el primer mensaje, las autoridades electorales brasileñas han aprendido o aprenden del proceso del 18, aprenden el proceso del 20, van tratando de articular una capacidad de respuesta tanto en términos organizativos, en términos estructurales de la organización del tribunal, como en términos de redes distintas de respuesta, de los que luego hablaré muy brevemente. Y cuando de alguna manera ocurre lo previsto, que es que el volumen de desinformación se dispara durante el proceso electoral, les coge preparados. Y esto es el primer mensaje. O sea, hubiera sido imposible dar una respuesta, articular una respuesta eficaz en términos real cuando estalla o cuando se ve la dimensión o el volumen absolutamente brutal de la desinformación durante la campaña. Según datos del presidente del Tribunal Superior Electoral, y aquí, como he dicho, puedo caer en mi error, pero según los datos que yo tengo, en las elecciones, o sea, el volumen de la desinformación aumentó un 1.600% entre el año 2020 y el año 2023. Esto me parece que nos da una idea de lo que estamos hablando, ¿no? Y además con una peculiaridad que distingue, en mi opinión, las elecciones del 20 de las del 23, que es que en la desinformación del año 23, en una gran parte, o una buena parte de esa desinformación, se centra básicamente en la denuncia de la credibilidad del propio proceso electoral en sus distintas fases, ¿no? O sea, es un cuestionamiento directo a la legitimidad del proceso, donde, como decía antes, las denuncias sobre el funcionamiento del voto electrónico cogen un protagonismo especial, y cogen un protagonismo especial, y esto sí que creo que es mejor, si quieren, que lo cuenten ellos, pero que adquiere una forma, en términos de metanarrativas, espectaculares. O sea, se juntan 80 hilos distintos en los que hay todo tipo de derivadas o de perspectivas pero que todas inciden y van haciendo cada vez más grande, más creíble, una misma idea, que es que el fraude se va a producir a través de las máquinas de votación electoral, ¿no? Y para llegar hasta ahí no es una idea repetida 1000 veces que se acaba convirtiendo en verdad, por decirlo de alguna manera, como decían los clásicos, sino que realmente son 1000 ideas distintas que convierten una idea en verdad. Y esto me parece que es muy llamativo porque pone de manifiesto la dificultad, claro, porque contestar a una idea es relativamente fácil y al final es un tema de volumen, pero contestar a 1000 ideas distintas, pues siempre se te acaba colando alguna, ¿no? Bien, en este contexto, y me avisas si me paso, que aquí no... me parece que hay un primer problema, que es que el marco normativo, y a pesar de haber aprendido de la experiencia en el tema del marco normativo, y esto no es responsabilidad de los organismos electorales, como todos saben, el marco normativo no era adecuado. Y en mi opinión obliga al tribunal a tomar una serie de decisiones que fuerzan, o sea, que de alguna manera se justifica en la ausencia del marco normativo y, por tanto, salió ayer aquí de una forma bastante brillante la necesidad de estirar lo que se tiene para dar respuestas, y esto creo que es de alguna manera justificable, pero la realidad es que el marco normativo no está adaptado a la magnitud del problema y esto pues acaba generando tensiones durante su ejecución o durante su proceso. Dicho esto, la estrategia del tribunal se basa en 3 pilares y esto me parece que es interesante y luego ellos van a concretar mucho más, ¿no? La información, que permite a los ciudadanos ejercer el voto de manera consciente e informada. La capacitación, para que tanto los ciudadanos y los servidores públicos entiendan el problema y mejoren su capacidad crítica. Y la moderación, que como ya ha ido saliendo durante estos días, es quizá el aspecto más complejo y que el programa de las autoridades brasileñas denominaba el control del comportamiento, que aquí suena un poco raro, pero que incluía en casos excepcionales, según el mismo programa, y cito literalmente porque creo que en este punto es importante, el control de contenido por medio de monitoreo de casos y prácticas de desinformación, direccionamiento de recursos tecnológicos y actividades preventivas y represivas contra comportamientos inauténticos, el uso de propaganda computacional y las acciones coordinadas de propagación de información. Y aquí me parece que hay un elemento que también nos ayuda de cara a sacar lecciones de esto, ¿no? Que es que se afronta el problema ya desde el principio en todas, o al menos en casi todas sus perspectivas. Se ha insistido mucho en el carácter híbrido de estas amenazas, en su diversidad y en que no podemos hablar solo de fake news o solo de desinformación en general. A nosotros nos gusta hablar de distorsiones informativas, pero aquí en la propia definición de las acciones esto queda claro, ¿no? A partir de ahí, como digo, no voy a entrar en analizar todas las medidas que se adoptaron, pero me parece que lo que llama la atención, además de la previsión y la continuidad en el tiempo, es la diversidad de la respuesta. O sea, si hay otra cosa que creo que está quedando clara en estas jornadas y que cada vez vemos más clara, es que no se puede resolver el fenómeno de la desinformación electoral solo con medidas administrativas, solo con un marco normativo adecuado, solo con acciones de información, solo con acciones de educación, sino que hay que integrarlas todas y en esa integración es donde en gran medida se juega el éxito del proceso. Y en ese sentido creo que el Tribunal Electoral adoptó cientos, y ya insisto, ya lo contarán, cientos de medidas que todas coordinadas dan una idea. Acabo y simplemente mi valoración general y, como digo, pues quizá condicionada, pero del proceso en general. O sea, me parece que la actuación de los organismos electorales brasileños para hacer frente a la desinformación fue una decisión que muestra su carácter estratégico y que esto es esencial. Que tenía objetivos claros y dotó, y aquí puede haber debate, pero de recursos suficientes o bastantes para hacer frente a esto en lo que supone una buena definición de la estrategia. Realista, asumiendo la dimensión del problema, pero también las capacidades que contaba para enfrentarlo y seleccionando una serie de acciones prioritarias frente a otras en las que no había tiempo o recursos para llevarlo a cabo. Integral, como ya he dicho, teniendo en cuenta no solo todo tipo de canales, sino todo tipo de acciones o de objetivos que se interrelacionan entre sí, permanente y previo, en el sentido de que no es una acción reactiva, sino que es una acción que la mayoría de su tiempo se dedica a prepararse y que cuando estalla el problema, por decirlo de alguna manera, está preparado y, en mi opinión, bastante preparado, por eso además de permanente es proactiva, colaborativa, o sea, es una acción en red que consigue involucrar a cientos de actores, de los que se hablará, y aquí es donde está, si podemos decir, mi gran crítica, o mi crítica, que no es grande, pues que tensiona el marco normativo y que en ocasiones acaba generando ciertas dudas porque porque al no existir un marco normativo adecuado a una realidad específica y con una naturaleza propia, pues en mi opinión se acaban adoptando decisiones que contradicen decisiones previas y que acaban generando ciertas tensiones en el sistema jurídico. Yo no sé si he sido capaz de cumplir mi objetivo de no meterme en su materia y de darles un marco adecuado, pero al menos lo he intentado. Muchísimas gracias.
Agradeço ao professor Rafa Rubio, que trouxe panorama muito extenso em conteúdo, né, mesmo com o tempo limitado e respeitando bastante tempo. Obrigado, professor. Na sequência, gostaria de passar a palavra para a professora Ana Cláudia Santana. Uma grande honra tê-la aqui hoje. Sabemos da dedicação que a senhora teve para chegar aqui hoje, para a gente poder ter essa conversa. Então, agradeço muito a sua presença. A professora Ana Cláudia Santana, ela é doutora e mestre em Ciências Jurídicas e Políticas pela Universidade de Salamanca, Espanha. Tem pós-doutorado em Direito Público e Econômico na Pontifícia Universidade Católica do Paraná, no Brasil, e em Direito Constitucional na Universidade do Externado, em Colômbia. Professora de Direitos Humanos, Direito Constitucional e Eleitoral, é pesquisadora do projeto Magistratura e Direitos Humanos no Brasil, coordenado pelo Programa e pela Pós-Graduação da PUC do Paraná e pelo Conselho Nacional de Justiça. E a professora também é coordenadora geral da Transparência Eleitoral Brasil. Professora, a senhora tem a palavra. Muito obrigado.
Hola, muy buenos días a todos y a todos. Yo voy a pedir permiso para hablar en español porque justamente me da muchísimo gusto estar aquí en España otra vez y a mí me gustaría saludar a todos los españoles y españolas que desde siempre me acompañaron en mi vida académica. Me gustaría saludar la mesa en la persona del profesor Rafa Rubio, a quien agradezco la muy amable invitación para participar del evento, y además saludo a mis compañeros de mesa. Bueno, 12 minutos para hablar del tema del sistema electrónico de votación, ya podéis saber que es un desafío que quizás yo no logre con mucho éxito hacerlo. Sin embargo, yo tengo una investigación que desarrollé justamente tomando aquí un poco el tema que Rafa nos ha dicho de la desinformación. He participado directamente del debate sobre el voto imprimido, lo que nosotros llamamos en portugués de voto impreso, en el Congreso Nacional de Brasil, que es la propuesta de enmienda constitucional 135-2019, que fue de hecho un espacio de mucha desinformación. O sea, es bastante posible que nosotros cooptemos un debate muy legítimo que es la mejora y el perfeccionamiento del sistema electrónico de votación para otros fines que no exactamente mejorar el sistema mismo. Y esto fue el caso que pasó en el Congreso Nacional. Y afortunadamente esta propuesta de enmienda a Constitución no fue aprobada al final. Sin embargo, esto no fue hecho solo con, por así decir, la resistencia de los parlamentarios, sino más bien de una aclaración muy amplia de lo que era el sistema electrónico de votación, cuáles eran sus virtudes y cuáles eran eventualmente sus puntos a mejorar. Y de esto voy a hablar. Por lo tanto, aquí voy a aplicar una metodología de políticas públicas para analizar el sistema electrónico de votación brasileño y por eso aún más hablo en castellano, porque me parece que el sistema electrónico de votación que es como un escaparate para Brasil, para el mundo, tiene que ser mejor comprendido no solo por los extranjeros, sino por los otros mismos brasileños. Bueno, dicho esto, voy a aplicar aquí el concepto de política pública como una estrategia que pasa por una elaboración del problema, o sea, la identificación de un problema, la identificación de una estrategia y aplicación, la decisión de construir esta política pública, así como su aplicación, evaluación, para luego empezar otra vez dicho ciclo. El sistema electrónico de votación en Brasil tiene una razón muy importante que aquí nosotros todos tenemos que tener muy claro. Teníamos un problema grave de fraude en las elecciones brasileñas, desde siempre. Cuando teníamos el papel, la boleta en papel, teníamos muchos fraudes, pero descarado. De eso se trata. Por lo tanto, aquí tenemos un problema. El problema que deberíamos solucionar era la eliminación de fraudes. Y de esto me parece que el sistema electrónico de votación fue muy exitoso justamente porque disminuyó muchísimo el contacto humano. Es decir, el error humano, por un lado, porque puede que el fraude no es fraude, sino es intencional, puede que sea un error. Sin embargo, los fraudes son intencionales con contacto humano. Y de eso, a mí me parece que esa es una gran virtud del sistema electrónico de votación. Y, claro, en este punto, la implementación del sistema electrónico de votación desde 1996 fue súper importante para nuestro desarrollo como sociedad y como una democracia. Yo, por ejemplo, yo tengo 41 años y nunca voté en boleta de papel. Nunca. Siempre he votado en la misma máquina que al día de hoy sigue realizando nuestras elecciones. Bueno, dicho esto, de 96 hasta el día de hoy, el mundo cambió, las sociedades han cambiado y nuestra noción de seguridad ha cambiado profundamente. Si antes teníamos como noción de seguridad una caja fuerte, escondida, con un secreto enorme, el día de hoy no es así. Yo tengo que mostrar que la seguridad es de hecho segura. Y de eso estamos hablando entonces de transparencia. Y aquí debo decir que en los últimos años, principalmente desde 2020, la justicia electoral ha puesto mucho esfuerzo para traer transparencia sobre el sistema electrónico de votación. Quizás un poco tarde, pero siempre es tiempo para empezar una gran estrategia de aclaración y de conocimiento de lo que pasa en la parte organizacional de las elecciones. Y aquí voy a mencionar la Comisión de Transparencia de las Elecciones, que fue un órgano interno del Tribunal Superior Electoral que fue adoptado en final 2020, si no me equivoco, en diciembre, lo cual igual Transparencia Electoral Brasil hizo parte como representación de la sociedad civil. Y algunas de las decisiones que fueron tomadas en el ámbito de la Comisión de Transparencia de las Elecciones fueron súper importantes para 2022. De hecho, para quitar los argumentos de las personas que querían construir narrativas, desinformación, etcétera, como la publicación inmediata de los boletines de urna, que es justamente los resultados de las urnas electrónicas, de las sesiones electorales por todo el país, y la disponibilización digital de los logs de las urnas, que es exactamente lo que pasó con aquella urna en todo el día de la votación. Esto fue algo súper importante en términos de transparencia, y aunque, bueno, en otros casos, obviamente hay algunos pasos que todavía tenemos que seguir tomando, pero hubo avances. Y de este punto podemos pensar entonces en una política pública, porque si tenemos como problema identificado una desinformación enorme, lo que nosotros hemos visto igual en 2022 fueron esfuerzos en la dirección de una mayor transparencia. Sin embargo, hay que mejorar la educación para el voto. La misión de observación electoral de Transparencia Electoral Brasil, que fue la mayor realizada en 2022, acreditada por el Tribunal Superior Electoral, identificó que la educación para el voto todavía es una cuestión, una tarea por hacer. ¿Por qué? Porque esto demuestra que las personas no comprenden ni la urna electrónica y tampoco la tecnología alrededor del voto. Y no estoy hablando de las personas urbanas, estoy hablando de las personas del interior del país, las personas que están alejadas de los centros urbanos, porque ellas también tienen el acceso, tienen que votar de manera tecnológica, y la diferencia generacional aquí cuenta mucho, porque los jóvenes se encuentran muchísimo mejor con las nuevas tecnologías, sin embargo los mayores no. Y nosotros hemos visto un contingente enorme de mayores que les gustaría participar más, que están para participar, que quieren votar y han tenido algunos problemas, y en algunas situaciones de hecho ellos miraban la urna electrónica y cómo se asustaban. O sea, hubo un alejamiento de estos dos elementos que nosotros hemos podido ver a lo largo de las dos vueltas de las elecciones. Dicho esto, en la etapa 1 de la metodología de políticas públicas, nosotros ya hemos hecho entonces la identificación del problema, que no es exactamente la seguridad del sistema electrónico de votación, porque nosotros, especialistas, sabemos que es bastante seguro. Y de hecho fue bastante comprobado por muchos canales de que el sistema efectivamente funciona, es seguro. Sin embargo, tenemos un problema de conocimiento de esta tecnología que hace parte de nuestros tiempos, porque al fin y al cabo la tecnología se desarrolla con una velocidad muy alta y tenemos la tarea de siempre explicar a las personas, porque ellas también tienen el derecho de entender qué está pasando con sus derechos y principalmente con los derechos políticos en este caso. Por lo tanto, tenemos una cuestión de transparencia y de información. Como Rafa Rubio ha dicho, hay un conjunto de acciones que tienen que ser tomadas simultáneamente para que podamos combatir la desinformación, por ejemplo. La etapa 2 de la política pública que os estoy proponiendo es un aumento de la transparencia y la educación para el voto, y aquí en este caso tenemos que pensar obviamente en una estrategia muy amplia para incluir a los brasileños y las brasileñas con una aproximación mayor a la urna electrónica, con presupuesto adecuado, cronograma, recursos humanos y un lenguaje bastante accesible para todo el tipo de gente que está en este momento ejerciendo su derecho de voto en Brasil. Y obviamente no estoy diciendo que no está siendo hecho, estoy diciendo que por medio de una metodología de política pública podríamos elegir actuar en estos frentes justamente para mejorar, para perfeccionar el sistema electrónico de votación. Bueno, luego, un calendario para eso, para la ejecución de esta política pública sería muy importante, justamente porque en años no electorales son una buenísima oportunidad, una ventana de oportunidades que nosotros decimos para la educación para el voto, para aclarar puntos que no están debidamente aclarados. Y aquí, obviamente, claro, todo depende de factores institucionales, presupuestarios. Actualmente en Brasil hemos tenido una transición de gobierno bastante importante que cambió muchísimo, muchas cosas. Entonces, obviamente hay una cuestión de agenda pública. La etapa 4, que podríamos hablar entonces de la evaluación de una política pública para el fomento y perfeccionamiento, mejor diciendo, del sistema electrónico de votación, que teníamos que pensar en la confianza que tiene que ser rescatada, porque el sistema puede funcionar como maravilla, pero si la gente no se fía de él, no sirve para nada. De eso se trata. Por lo tanto, aquí tenemos que trabajar con la confianza, tenemos que trabajar con la idea de que la confianza se rompe muy rápidamente de lo que se construye. Entonces, tenemos que reconstruir una confianza que en su momento ya la tuvimos. Y a mí me parece que en algunas generaciones atrás, Brasil confiaba muchísimo en la urna electrónica, en la justicia electoral. De hecho, las encuestas públicas demostraban eso. La justicia electoral tenía muchísima legitimidad ante la sociedad. Sin embargo, el cuadro ha cambiado y tenemos que trabajar con este contexto que es desafiador y al mismo tiempo nuevo, donde el Poder Judicial sí está enfrentando una crisis de legitimidad ante la sociedad y tenemos que trabajar con esto. No es suficiente, y aquí una opinión estrictamente personal, no es suficiente que el Poder Judicial se tome exclusivamente la tarea de aclarar y hablar sobre la confianza de las urnas electrónicas, porque no va a funcionar. Tenemos que aquí sumar fuerzas con muchos actores sociales para que otras personas con otro tipo de legitimidad igual entren en el debate y puedan construir conocimiento y llevar información a todas estas personas. De esto se trata. Aquí, otro punto que me parece bastante importante es el trabajo continuado entre generaciones. Está claro de que en el inicio de la implementación del sistema electrónico de votación en Brasil, mucho se hizo para aproximar la urna de las personas. Había urnas en las escuelas, había urnas, en muchos espacios diversos que no eran exactamente institucionales. Y esto, obviamente, familiariza la tecnología con las personas. Sin embargo, de alguna manera u otra, y aquí no tengo muy claro qué pasó porque estuve fuera de Brasil por mucho tiempo, hay un gap, hay una laguna entre generaciones que no se sienten más incluidos o entonces familiarizados con la urna electrónica del día de hoy. Y aún más ahora, con el nuevo modelo de 2020, tenemos una nueva tarea por hacer y una popularización, por así decir, de la urna electrónica y de cómo funciona esta tecnología. Es importantísimo hablar sobre eso. Y claro, todo esto junto en línea con un trabajo de desinformación que el Tribunal Superior Electoral hace muy bien y que ya fue reconocido por otros actores internacionales. Por lo tanto, una acción no quita la otra, no excluye la otra. Y, bueno, podemos trabajar igual con encuestas de personas para que digan si están confiando más o menos. Eso se hizo bastante en 2020, si no me equivoco, 2021. Me parece que es una buena herramienta para evaluar una política pública de mayor transparencia y conocimiento sobre el sistema electrónico de votación. Bueno, las encuestas pueden ser más fieles o no. Sin embargo, a mí me parece que hace parte. Y para cerrar, porque mi tiempo ya se esgotó, como conclusiones, aquí tenemos que pensar que esta tarea, esta política pública no tiene caducidad. Es decir, tiene que ser implementada ya, tiene que ser continuada, no puede parar en años no electorales, porque las personas tienen que parar de pensar que la justicia electoral, por ejemplo, solo trabaja en elecciones. Esto no es verdad. Y además tenemos que pensar en medios, en canales de aproximación de las personas con la justicia electoral, con el sistema electrónico de votación y no solo institucionalmente, que las personas se sientan identificadas, que tengan orgullo de lo que tengan como tecnología para la democracia brasileña. Porque sí es cierto de que un electorado con más de 150 millones de electores listos para votar, con todo arreglado, es una razón para enorgullarse. Muchísimas gracias y perdona por el tiempo. Gracias.
Agradeço, professora, e agradeço, inclusive, a atenção com o tempo. Na verdade, a senhora brindou com bastante conhecimento da sua experiência, que é bastante larga em relação ao processo eleitoral brasileiro, e conseguiu também atender muito bem ao tempo. Muito obrigado por isso. Na sequência, eu gostaria de passar a palavra para o professor Vinícius Quintino de Oliveira. O professor Vinícius é doutorando em Direito pela Universidade Complutense de Madrid, ele é mestre especialista em Direito Público, ele é investigador do projeto de investigação, Garantías, frente desórdenes informativos, aqui da Universidade Complutense de Madrid, professor do PNUD da ONU, vinculado ao Conselho Nacional de Justiça, e é pesquisador da Academia Brasileira de Direito Eleitoral e Político. Professor, eu vou colocar aqui, te passar o mouse, caso eu queira. O que é que eu vou passando aqui?
Como você preferir.
Ah, vale. Então, vou colocar aqui no começo.
Prueba antes, Vinícius, prueba. Está funcionando?
Se
a lo mejor no llega.
Ele está passando ou não?
Dá um clique na tela aí.
Aperta o espaço.
Agora sim. Não.
Tá não.
Você vai passando aí.
Eu passo aqui, né?
É.
Tá ok.
Então, boa tarde a todos e todas. Cumprimento aqui também os meus colegas de mesa na pessoa do professor Rafa. E o meu papel hoje aqui num evento que trata de ciberseguridade e eleição é trazer um pouco do contexto das eleições brasileiras de 2022 e mostrando outras ferramentas, tal como a professora Ana Cláudia acabou de dizer, que conseguiram agregar o valor suficiente para conformar esse nosso padrão ideal de confiança, que consegue, então, estabilizar o nosso sistema ou melhorar a estabilidade dos nossos sistemas em termos de integridade eleitoral. Vou trazer um pouco aqui do nosso percurso sobre a construção e a aplicação de um programa de missões de observação eleitoral, mostrando um pouco dos aspectos práticos e principalmente de como o aspecto político de um processo de missão de observação eleitoral conseguiu, então, agregar um valor super importante num contexto complicado, num contexto caótico, que foi a alteração de um padrão de confiança da estrutura eleitoral, principalmente do órgão eleitoral brasileiro, para um debate político super polarizado, onde a justiça eleitoral foi então deslocada para o centro desse debate foi, de alguma forma, atacada muito severamente. Para a gente começar a compreender os caminhos que foram percorridos, eu gostaria apenas aqui de lembrar do que nós estamos tratando. Rafa disse muito bem da dimensão do contexto eleitoral brasileiro, mas em síntese nós temos a maior eleição informatizada do mundo. Nós temos aproximadamente 150 milhões de votos que estão distribuídos aí em 5 mil municípios, com aproximadamente 500 mil urnas eleitorais, onde trabalham aproximadamente 2 milhões de pessoas, 2 milhões de mesários, distribuídos aí em 27 estados do país. São mais de 22 mil empregados, servidores da Justiça Eleitoral, um corpo de aproximadamente 3 mil juízes eleitorais, 3 mil promotores eleitorais e outras tantas, né, sessões eleitorais no exterior. Esses dados estão inseridos num contexto de um estado de dimensões continentais, aproximadamente 15 vezes o tamanho da Espanha, e com distribuições geográficas também super complicadas, o que reforçam qualquer estratégia da Justiça Eleitoral de enfrentamento à desinformação e enfrentamento aí do combate dessa escalada de desinformação que foi, então, sofrida em 2022. Bom, o que aconteceu, como estava o nosso contexto político, o que aconteceu para que hoje a gente pode, sem sombra de dúvida, dizer que houve um paradigma, uma alteração de paradigma em termos de aceitabilidade da participação da comunidade internacional nas eleições brasileiras. E aí ilustro, então, essa alteração que foi proposta pelo Rafa e pela Ana Cláudia com uma repercussão, né, na imprensa local sobre a aceitabilidade da nossa urna eletrônica e como o processo de desconstrução de desinformação ocorreu. Em 2009, nas últimas décadas, especialmente em 2009, nós tivemos então uma pesquisa popular que nos trazia uma aceitabilidade dos eleitores da urna eletrônica em termos na casa de 97%. Então nós tínhamos um cenário no qual o órgão eleitoral brasileiro estava muito bem solidificado, uma aceitação popular muito forte e praticamente não se questionava a integridade da Justiça Eleitoral em organizar a eleição da casa dos 97% de aceitação. O que aconteceu desde então e principalmente, sobretudo, tentando fazer um recorte, no final de 2017, com muita força nas eleições de 2018, 2020, então em 2022. A Justiça Eleitoral e o sistema eleitoral brasileiro foi colocado no centro de um debate ultrapolarizado, no qual campanhas de desinformação passaram então a utilizar pontos de dúvida com essa estrutura massiva e recorrente de informações contrárias ao que se de fato praticava e o que se de fato já tinha como reconhecido, o que afetou então a confiança e, por conseguinte, a integridade das eleições brasileiras e a legitimidade, então, desse órgão de continuar, questionando, então, a legitimidade desse órgão, então, de continuar fazendo eleições sólidas. Então, após essa campanha massiva, nós temos, então, um outro reflexo, já agora em 2020, no qual aproximadamente aí, 30%, um elevado índice, né, de desconfiança, passou a questionar a possibilidade das urnas eletrônicas servirem perfeitamente para representar aí a vontade da população. Bom, agora nós temos que verificar qual foi o contra-ataque, né, as estratégias de contra-desinformação que ocorreu na Justiça Eleitoral. Iniciou-se, então, a partir de meados de 2020, um estabelecimento de algumas medidas de contra-desinformação eleitoral. Estamos falando aqui de desinformação que atinge o órgão eleitoral. Então, nós tivemos uma reação estratégica muito bem definida. Nós temos na mesa um dos responsáveis, o professor Fred, que foi um dos autores dessa estratégia de contra-desinformação. Então, elaboramos um programa permanente de enfrentamento à desinformação e um programa de fortalecimento reputacional como medidas administrativas de tentar reposicionar a Justiça Eleitoral enquanto um órgão sólido e capaz de retomar essa posição de confiança das eleições brasileiras. Então, logo em seguida, nós tivemos efeitos dessa contra-investida, de maneira que, no final, né, de 2022, a confiança na justiça eleitoral retoma um patamar de aproximadamente 80% dos brasileiros que estavam, então, novamente, né, manifestando ou dando a sua opinião que as urnas eletrônicas brasileiras seriam capazes, então, de representar o voto. Então, veja, em um processo de desconstrução e reconstrução, nós percebemos que medidas de contra-informação, de contra-desinformação, que conformaram um programa de uma estratégia integral de atuação que previu medidas desde ciberseguridade, medidas de comunicação, medidas de educação cívica e medidas de chamamento, né, de aproveitamento da comunidade internacional para vir, observar e então avaliar as eleições brasileiras, e aí que entram as nossas missões de observação eleitoral. Nós tentando traçar uma linha uma linha de atos, de grandes marcadores, e aí a gente precisa fazer justiça à professora Ana Cláudia Santana, que nessa história diversos capítulos tiveram a participação da professora e da Transparência Eleitoral Brasil. Nós percebemos que esse contexto no qual a justiça eleitoral passou a ser inserida gerou uma alteração de paradigma da resposta do Estado brasileiro. Essa alteração nos proporcionou uma maior abertura à comunidade internacional, visto que antes o processo eleitoral brasileiro, apesar de historicamente receber por vezes convidados internacionais, né, ainda não tínhamos um modelo instituído de missões de observação eleitoral, tecnicamente, como se recomenda, principalmente pela Organização dos Estados Americanos. Então, essa alteração no paradigma permitiu que, em 2018, nós tivéssemos um primeiro projeto piloto, né? Na verdade, um primeiro projeto de missão ainda não institucionalizado para um programa pela Organização dos Estados Americanos, que, ao final, gerou um relatório que foi muito bem recebido pela comunidade, muito bem recebido pela sociedade e pela justiça eleitoral, seja pelos importantes dados coletados, pelas importantes recomendações que foram feitas e principalmente pela capacidade de agregar valor a um órgão que aí reclamava ou que tentava reforçar a sua reputação num contexto de impacto de desinformação eleitoral. Esse ambiente permitiu, então, que pudéssemos avançar, de modo que em 2020, além de uma missão de observação internacional, tivemos, então, uma primeira missão de observação nacional super inovadora, que foi muito bem organizada, que foi a missão da Transparência Eleitoral Brasil, que conseguiu cobrir boa parte do território nacional com metodologia sólida, com uma estrutura de capacitação das pessoas observadoras e que ajudou a conformar esse novo ambiente de recepção de missões de observação eleitoral, né? Uma estratégia de entrada muito bem sucedida permitiu que daí, então, pudéssemos discutir outros grandes avanços, que é, primeiro, o estabelecimento de um marco normativo que garantia a independência, que pudesse garantir a autonomia de que as missões de observação eleitoral precisariam para exercer, então, o seu desafio, o seu munus, com bastante autonomia e independência. Então, após uma discussão social forte, pública, transparente, após diversas audiências públicas, após a abertura para a recepção de sugestões, avaliações, bastante reflexão, eis que então a Justiça Eleitoral aprova uma resolução 23678 de 2021, que estabelece textualmente direitos, deveres, processos de acreditação, processos de avaliação, prazos, direitos, né, obrigações, algumas normas, alguns elementos de acreditação, mas que, de fato, a importância de ter isso textualmente regulamentado por um processo que continuamente buscava uma solidificação dessa ferramenta enquanto uma outra medida capaz, né, de alguma forma combater essa desinformação que afetava a justiça eleitoral, foi então muito bem sucedida. Em 2022, então, nós chegamos num contexto, e aí caminhando para o final, um contexto que, na nossa avaliação, foi um contexto de muito sucesso. Vejo aqui, por exemplo, grandes nomes que estiveram conosco, magistrado Vargas, nós temos a professora Unravel, próprio Rafa, nós tivemos Alberto Guevara, que estão conosco aqui hoje, que estiveram no Brasil, que acompanharam, que conseguiram todo o apoio e transparência para que a metodologia, né, acordada e aprovada pudesse ser cumprida da melhor forma possível. Ao final, os nossos resultados apontaram 16 missões de observação eleitoral com as organizações mais respeitadas do mundo. Nós tivemos o Centro Carter, a Organização dos Estados Americanos, nós tivemos observações técnicas como o AIFES, observações específicas como do Laboratório de Desinformação da Universidade Complutense de Madrid. Nós tivemos 8 missões nacionais, 8 missões internacionais e outras 2 grandes missões de acompanhamento eleitoral. Isso dentro de um contexto que conseguiu cobrir todos os estados da Federação Brasileira. Um país continental, 27 estados foram cobertos. Claro que é um ponto que merece melhoria, dado o tamanho do Estado brasileiro, a capacidade da gente coletar dados que, de fato, representem estatisticamente a realidade brasileira. Mas nós tivemos mais de 500 observadores, mais de 80 grandes personalidades e especialistas em direito eleitoral observando o processo eleitoral brasileiro. Fizemos um grande programa, né, de convidados internacionais que não ocorreu especificamente na semana das eleições, mas ao longo de uma longa data, por uma participação virtual, foram centenas de reuniões técnicas, reuniões que, por vezes, estavam relacionadas a desinformações que voltavam a circular no contexto eleitoral. Então, esse espaço de abertura para que missões de observação internacional pudessem participar gerou, então, um número elevado, né, de reuniões com núcleos técnicos do tribunal. Nós tivemos participação de praticamente todas as embaixadas internacionais que estão sediadas em Brasília. Foram mais de 100 países que, por vezes, acompanharam os nossos eventos, os nossos chamamentos públicos, né? O que gerou, direto ou indiretamente, um reflexo na imprensa, um reflexo na formação de opiniões de países, e o que ajudou a conformar, então, esse ambiente favorável de contra-desinformação e fortalecimento reputacional da justiça eleitoral pela comunidade internacional. Então, caminhando para o final, em síntese, isso ajudou a reforçar o nosso modelo de cooperação internacional, e aí nós temos vários exemplos de países que nos procuraram, então, que procuraram a justiça eleitoral para estabelecer esse tipo de comunicação. Pode passar, Vitor, por último? Esses são alguns exemplos de países que manifestaram interesse de conhecer melhor e aprofundar na justiça eleitoral. Então, ao final, o que nós temos para concluir é que, nesse contexto de ampliação da desinformação que afeta os órgãos eleitorais, a iniciativa da justiça eleitoral de abrir para a observação eleitoral internacional acabou contribuindo para uma solidificação de uma boa prática recomendada pelos organismos internacionais e agregando valor, fortalecendo a integridade eleitoral brasileira e, então, solidificando uma proteção da confiança que é fundamental para estabelecimento da legitimidade de uma eleição como é uma eleição brasileira colocada à prova. Muito obrigado.
Você me devolve o teclado? E eu te mando o mouse. Obrigado. Então, agradeço ao professor Vinícius por sua exposição. Na sequência, eu já passo, então, a palavra para o professor Frederico Alvim. O professor Frederico é doutor em Ciências Jurídicas e Sociais, doutorando em Ciência Política pela Universidade de Lisboa. Ele é mestre em Direito, pesquisador da Academia Brasileira de Direito Eleitoral. Ele é membro do comitê científico desse evento que estamos realizando. Ele é autor de diversas obras na temática eleitoral, dentre as quais Abuso de Poder nas Competições Eleitorais, Cobertura Política e Integridade Eleitoral, Efeitos da Mídia nas Eleições, e é coautor de obras da obra Guerra Cognitiva na Arena Eleitoral, o controle judicial das eleições, que está no prelo, já está para sair agora, bem brevemente. Então, professor Frederico, eu passo a palavra para o senhor.
Muito obrigado, Vitor. Bom dia a todos e todas. Bom, eu tenho o desafio aqui de falar em 12 minutos de um tema que mereceria, mais propriamente, 12 horas. Eu parto da premissa de que a desinformação não é uma arte, a desinformação é uma ciência. Nós, que geralmente lidamos no direito para compreender esse fenômeno, devemos, como obrigação, acessar conhecimentos produzidos em pelo menos mais 15 campos da ciência. O problema é que esse conhecimento científico acumulado colabora para que a desinformação se desenvolva também de uma maneira mais eficaz, trazendo cada vez mais riscos para as democracias em um nível mundial. Basicamente, a gente poderia tentar compreender a engenharia da desinformação a partir de diversos aspectos organizacionais e estruturais. Alguns deles estão colocados aqui. A desinformação agita, por um lado, recursos humanos e recursos tecnológicos que podem ser colocados em prática para desenvolver uma série de estratégias e táticas que tendem a torná-la mais efetiva. Em alguns casos, essas estratégias são colocadas em prática como táticas de contágio, com o objetivo precípuo de garantir que a desinformação alcance maior visibilidade social, por um lado, e, por outro lado, que produza um efeito de conversão, de conversão de opiniões, que no campo da desinformação não é necessariamente um efeito de convencer as pessoas a respeito das narrativas fraudulentas, porque nesse campo em que se trabalha a produção sistemática de desconfiança, basta que a dúvida seja colocada em questão. Em outro campo, como a desinformação ocorre à margem dos ordenamentos eleitorais, desenvolvem-se também táticas de blindagem para assegurar uma fuga de responsabilização. Há aí também diversas questões que podem ser utilizadas em conexão também com táticas de distração, porque a desinformação é uma ferramenta de comunicação que também serve para substituição de agendas, toda vez que uma força, uma corrente política interessada em desinformação se vê acuada, se vê enfrentando alguma pauta jornalística ou social incômoda, a desinformação também pode servir para que a atenção pública seja desviada para outros fatores. É comum que se perceba que a desinformação ocorre de maneira organizada, envolvendo, por exemplo, uma estrutura relacionada com bases de financiamento, envolvendo também uma estrutura relacionada com o desenvolvimento de ferramentas tecnológicas e com a aplicação também de ferramentas humanas, como a gente já havia antecipado, mas o meu ponto aqui hoje é demonstrar que essa ciência também se desenvolve e essa estrutura organizativa também se projeta no próprio campo da linguagem, porque não basta para que a desinformação contagie o ecossistema informativo e contamine a esfera pública de um país, que a gente tenha toda uma estrutura órfã de uma matéria-prima, e a matéria-prima basicamente produzida no campo da linguagem. Obviamente, essa engenharia é uma engenharia profissional, ela envolve financiamentos estáveis, ela envolve planejamentos estratégicos e estruturas muito robustas. Mas o grau de profissionalismo e a magnitude dessa estrutura, ela pode variar de acordo com alguns elementos, né? Depender das capacidades econômicas dos agentes envolvidos, dos interesses que estão aí colocados em questão também, a vastidão das redes de apoio e, por fim, o próprio nível de risco que essas pessoas estão dispostas a enfrentar. E, nesse sentido, o desenvolvimento de um modal normativo adequado a erguer uma estrutura de desincentivo, obviamente, passa a cumprir um papel importante no sufocamento, no constrangimento da desinformação, porque, como dizia José Saramago, o melhor guarda da vinha é o medo que o guarda venha. Basicamente, esses trabalhos de inteligência, eles podem focar em diversos níveis e, comumente, há investimentos nesses três campos. Primeiro, trabalha-se para maximizar o alcance da desinformação. Segundo, para que se dificulte o rastreamento e a identificação dos responsáveis. Mas, por fim, e meu foco está aqui hoje, trabalha-se também para elevar a eficácia persuasiva dessas mensagens. Do ponto de vista da ciência cognitiva, acredita-se que basicamente existem 5 elementos que tendem a fazer com que o julgamento de plausibilidade de uma afirmação seja elevado e, portanto, os desinformadores trabalhando aí dentro dessa engenharia também têm algumas táticas e preocupações que, em primeiro caso, tendem a elevar a consistência das narrativas. Porque as narrativas desinformativas, elas são mais aptas ao convencimento quando elas são compatíveis com aquilo que as pessoas acreditam no campo do chamado viés de confirmação. Basicamente, aqui, então, trabalha-se para construir e manter câmeras de eco e também no campo da microsegmentação, né, através de cientistas de dados, consegue-se traçar um perfilamento de determinadas pessoas e segmentos sociais e, então, a partir daí, passar desinformações customizadas que tendem aí a atender ao gosto do freguês. Num segundo campo, é preciso trabalhar também a questão da coerência, é nisso aqui que eu vou focar em breve, mas é óbvio que são mais coerentes e mais capazes de convencer aquelas histórias que parecem fazer algum sentido. Daqui a pouco eu vou me aprofundar nisso. A credibilidade da fonte também é um elemento importante. A origem da informação é confiável. Trabalha-se, então, numa espécie de lavagem a fazer com que certas narrativas sejam amplificadas com instâncias que gozam de algum prestígio social, por exemplo, no campo de influenciadores, do que tecnicamente aqui dentro das investigações de desinformação nós chamamos de cabeças de rede. Trabalha-se também com uma legitimidade emprestada do sistema midiático, legitimidade essa que foi construída ao longo de pelo menos 2 séculos, mas que hoje resta captada no âmbito daquilo que se chama de mídia de reenquadramento ou de mídia de reframe, com os veículos noticiosos nato-digitais, que contribuem também para espalhar essas narrativas desinformativas. É óbvio que quando nós encontramos informações no campo da mídia, nós não necessariamente vamos acreditar nelas, mas em um efeito de reforço, quando essa mesma narrativa surge perante o público a partir de diferentes veículos, há um efeito de reforço, e esse efeito de reforço, ele é sim efetivo para produzir convencimento, e portanto os desinformadores não criam apenas um veículo nato digital, mas geralmente uma constelação de veículos que vão, com o uso de diferentes palavras, plasmar as mesmas narrativas, para que as pessoas, a partir dessa pseudo-impressão de que aquela afirmação é corroborada por mais de um jornal, também terminem acreditando naquilo que se coloca. A aceitabilidade geral também é um elemento muito importante. Quando outras pessoas parecem acreditar nessas narrativas, o nosso convencimento também fica facilitado. Dentro daí é clássico a prática, a tática do que se chama de astroturfing, né? Cria-se aí dezenas de milhares de contas falsas automatizadas que vão curtir, compartilhar, comentar no sentido de apoio uma determinada narrativa. Por exemplo, no âmbito das manifestações antidemocráticas convocadas ali para o 7 de setembro, um laboratório brasileiro identificou ali que mais de 12 mil contas que contribuíram para divulgar esses protestos antidemocráticos tinham sido criadas a menos de 3 dias da data-chave, né, da data em questão. E, por fim, outros fatores de corroboração, quando existem indícios materiais que parecem corroborar aquela história, isso também é algo muito interessante, e aí atende-se, então, assiste-se, então, ao surgimento de uma usina de criação de factoides, por exemplo, com a compra de pareceres de pseudo-especialistas, com apresentações feitas por pessoas também que fingem possuir um conhecimento que não tem numa atividade eminentemente impostora. Focando especificamente na produção discursiva, a gente começa aqui por fixar a ideia de que quando a gente fala de um discurso, a gente está falando de um processo comunicativo que está exprimindo um pensamento carregado de sentido. No campo da desinformação, esse sentido é um sentido sempre alheio e negativo. Ou seja, o discurso é sempre um discurso que tende a prejudicar a imagem social, de um lado, por um lado, em alguns casos, a imagem social de um oponente, pode ser um candidato, pode ser uma força política adversária, mas quando está associada à desinformação com o populismo autoritário, coloca-se sempre a questão da demonização dos chamados guardiões da verdade, né, das instituições democráticas-chave, portanto, das instituições de garantia. Cortes constitucionais e organismos eleitorais estão sempre aí, porque são elementos de contrapeso, são essencialmente instituições que garantem, que existem para garantir, né, que essas pessoas não avancem contra a Constituição. O sistema midiático, propriamente dito, também faz muito parte dessas narrativas de complô. E, por fim, as próprias instâncias acadêmicas também, que constroem uma legitimidade histórica a partir da produção generalizada de conhecimento, obviamente têm de ser atacadas também para abrir espaço para para narrativas negacionistas. E quando a gente está falando dos ataques às instituições eleitorais, basicamente a gente está falando de um tipo específico de negacionismo, né, que é o negacionismo eleitoral, o negacionismo de uma verdade incontestável de que as eleições têm um nível satisfatório de integridade dentro dessas democracias. Bom, esse discurso, obviamente, ele participa, então, de uma produção discursiva. A produção discursiva, num nível um pouco maior, ela parte de uma atividade, né, que desenvolve discursos que têm o sentido de conferir força, de conferir peso a alguns projetos políticos, articulando a linguagem em ação no sentido de produzir influência. E, portanto, a gente está falando de uma atividade essencialmente persuasiva. Porque, no âmbito da desinformação, o que se quer fazer é conseguir que as pessoas, a partir dessa argumentação retórica, sejam convencidas e, portanto, pensem, acreditem ou ajam de acordo com os interesses das instâncias desinformadoras, né? Quando a gente está falando de populismo autoritário, então, a gente está falando de táticas de manipulação que se retroalimentam, que se comunicam entre si, não é nada aleatório, é tudo articulado e tudo tem um sentido de reforço dentro de uma articulação dessa produção discursiva que envolve, num nível macroscópico, a construção de metanarrativas que são cotidianamente regadas, alimentadas, reforçadas por narrativas que guardam coerência lógica entre si. Basicamente, então, quando a gente fala de narrativa, a gente está falando de um relato que é mais ou menos organizado, né, que busca enquadrar ou reenquadrar um fato de acordo com a perspectiva autointeressada daquela instância que produz, e com o fim específico de atribuir um valor negativo ou um adversário ou uma instituição de contrapeso. Já a metanarrativa é aquela narrativa maior, né, que vai se tornar mais pertinente, que vai se tornar mais convincente na medida em que ela seja cotidianamente reforçada por diversas questões. E basicamente o que a gente consegue fazer aí, para usar uma expressão do Inácio Ramonet, é criar teorias enganadoras de amplo espectro, porque ao fim e ao cabo, para que a desinformação surta efeito na população, as pessoas não precisam exatamente estarem de acordo ou terem sido convencidas de uma historieta, de um conto ou de outro. Basicamente o que se basta é, através desse mecanismo reiterado, contínuo, iterativo, assegurar que as pessoas fiquem de uma maneira mais difusa com uma ideia na cabeça, e essa ideia na cabeça é que alguma coisa de muito errado e de inaceitável, de ultrajante tem acontecido e que, portanto, é preciso agir contra isso. Se a gente analisa toda a desinformação, toda essa produção feita de maneira industrial, né, contra as instituições eleitorais brasileiras ao longo do último ciclo eleitoral, a gente vai conseguir basicamente identificar 3 grandes metanarrativas. A primeira grande e principal metanarrativa é a narrativa de que as eleições brasileiras seriam fraudadas. Vejam o absurdo, não se estava tentando plasmar não apenas a ideia de que as eleições, por vir as eleições de 2022, seriam fraudadas, mas que, inclusive, essa fraude viria acontecendo já desde outros ciclos. E, para isso, vão se distribuindo narrativas falsas, narrativas fraudulentas que se sucedem, que são resgatadas, reinventadas, repaginadas o tempo todo e que, ora, vão atingir o código-fonte das urnas eletrônicas, ora vão atingir o cadastro de votantes ou qualquer outro elemento essencial para que a gente tenha, de fato, eleições íntegras. Num contexto mais institucional, há também uma sucessão de narrativas fraudulentas que miram a instituição justiça eleitoral e não o produto processo eleitoral em si. Aqui haverá narrativas que vão atribuir aos órgãos julgadores da justiça eleitoral uma atuação suspeita, uma atuação parcial, uma atuação abusiva, que as equipes técnicas de desenvolvimento de softwares e de segurança de urna eletrônica são inaptas, e isso aqui envolve também, num ambiente ainda mais sujo, ataques ad hominem a autoridades eleitorais. E, por fim, dentro desse contexto de ataque à democracia, em sentido geral, e não só o coração da democracia, processo eleitoral, sucedem-se também narrativas desestabilizadoras, com o uso de retórica do medo, com o uso de retórica uma retórica do inimigo com uma discussão em nível de criação de uma guerra cultural que passa para as pessoas uma ideia de que elas estão diante de uma ameaça existencial e que é preciso, portanto, lutar contra as instituições de garantias porque elas foram subvertidas e estão trabalhando no sentido de implantar uma ditadura no país. Há também narrativas que distorcem o sentido ou alcance de cláusulas constitucionais. Busca-se aqui não uma legitimação fática, mas mesmo uma legitimação normativa para um golpe de Estado, como se houvesse alguma cláusula constitucional apta a legitimar, a autorizar a intervenção do Exército sobre as instituições civis. E há aqui também teorias um pouco mais amplas também que fixam a existência de um determinado complô entre o judiciário e a mídia internacional. Isso se chama, basicamente, num conjunto amplo, uma estratégia que se chama de fire hosing. É como se houvesse uma mangueira de incêndio espalhando desinformação o tempo todo sobre tudo aquilo que pode parecer importante, sobre tudo aquilo que tenha um capital para deixar as pessoas indignadas, revoltadas e, portanto, mais vulneráveis a aceitar esse tipo de situação. Basicamente, apenas nos últimos meses do ano passado foram recebidos pela Justiça Eleitoral Brasileira mais de 43 mil denúncias de desinformação nas redes sociais. Aqui a gente não está falando tão apenas de narrativas falsas, mas dentro desse conjunto nós temos também denúncias relacionadas não com o conteúdo, mas com o comportamento inautêntico e, portanto, contas automatizadas, contas falsas, disparos em massa e outras coisas que são ilegais à luz das leis brasileiras. Isso provocou, nós já enfrentamos a desinformação de maneira muito forte em 2020, mas em 2022 nós tivemos um aumento aí na casa de 566%. Foram basicamente identificadas 244 grandes narrativas falsas diferentes que foram, por sua vez, desmentidas em 612 matérias de checagem de fatos por agências independentes do Brasil.
Professor Frederico,
pois não?
Peço desculpa, temos mais um minuto.
Perfeito, eu estou na penúltima tela, obrigado. Isso representou um aumento de 123% em relação ao ciclo anterior. Os efeitos políticos estão aí, a tentativa de golpe de 8 de janeiro com a invasão da sede dos 3 poderes, lá em Brasília, e só para afirmar, de novo, a necessidade aqui já veiculada de que nós tenhamos um sistema próprio de atuação judicial para desincentivar e punir os desinformadores se faz essencial, especialmente pelo fato de que no plano da comunicação, que também é essencial, mas não é suficiente, nós não conseguimos combater as instituições democráticas, não conseguem lutar contra os desinformadores em condições de igualdade. O campo aqui é sempre um campo nivelado. Por quê? Em primeiro lugar, porque os desinformadores, eles têm vantagens ilegítimas, eles atuam na ilegalidade, usam comportamentos inautênticos, usam robôs, usam táticas de linguagem, eles também têm a irresponsabilidade como método, como a matéria-prima do desinformador é a fantasia, é a ficção, eles não têm nenhum limite para criar histórias dramáticas, para criar histórias capazes de agitar sentimentos negativos, porque os sentimentos negativos são o motor pulsante da desinformação. E, por fim, como eu já tinha dito, tem uma engenharia profissional. Do outro lado, as instituições democráticas têm barreiras institucionais. Primeiro, precisam respeitar a legalidade e precisam respeitar a institucionalidade. Não podem atacar, mesmo quando são atacadas cotidianamente. Por fim, tem também a responsabilidade ética como um norte imperativo. As instituições democráticas praticam uma comunicação que é ética, uma comunicação que é violenta e, portanto, menos passível de convencimento e baseia-se não em fantasias, mas em dados oficiais verificáveis, e a burocracia é uma matéria chata, aborrecida, que não tem essa capacidade de manipular o imaginário público. E, por fim, principalmente, nós temos um ônus argumentativo super elevado, porque o desinformador pode simplesmente dizer que a Lua é feita de queijo, mas para desmentir essa narrativa, a gente precisa estudar um tratado de geologia e outro de astronomia para fazer esse tipo de resposta, e obviamente a complexidade também dificulta o plano da comunicação. Muito obrigado a todos e todas.
Muito obrigado, professor Frederico.
Obrigado.
Eu posso pegar o mouse de volta?
Claro.
Mas agora já caminhando para o... Obrigado, professor. Para o encerramento. Para o encerramento, eu vou trazer aqui minha fala, mas será muito breve, já que a gente teve as apresentações foram absolutamente substantivas, muito fortes, trouxeram boa parte do que eu já ia falar. Então, facilitaram muito, eu vou dar mais tempo para a gente poder trazer algumas perguntas. Basicamente, eu sou também pesquisador aqui da Universidade Complutense de Madrid, integro o Observatório Complutense de Desinformação. E o que eu queria trazer hoje, um enfoque específico no processo eleitoral brasileiro, dentre tanto que a gente poderia trazer, é do papel dos parceiros, dos associados ao programa de desinformação brasileiro, que teve um aspecto muito importante, inclusive no que a professora Ana Cláudia trouxe, que é justamente no fortalecimento da confiança no processo. Como já foi dito aqui e redito, um dos maiores ativos que a justiça eleitoral brasileira viu sendo atacado foi justamente a confiança. Porque mais do que a gente ter um processo eleitoral que a cada ano cresce, isso é identificado por toda a população brasileira, cada ano temos mais mecanismos de controle, cada ano a justiça eleitoral tem urnas eletrônicas com mais transparência, mais mecanismos de transparência, de auditabilidade, mas enquanto ele cresce em performance, há um decréscimo relativo à confiança no processo eleitoral. Então, a gente tem uma melhora de performance com a perda de confiança, o que não parece fazer sentido, e é justamente aí que a gente observa o impacto da desinformação. Então, o trabalho foi, dentre vários trabalhos, de fortalecimento da confiança no processo. E, dentro dessa perspectiva, foi desenvolvido, no âmbito da Justiça Eleitoral brasileira, um programa de enfrentamento que ele tinha como norte uma abordagem dialógica, cooperativa, sistemática, multidisciplinar e multissetorial. Nessa perspectiva, o TSE, compreendendo a incapacidade de qualquer órgão individualmente combater a desinformação como esse método de engenharia tão complexo, ele desenvolve um papel muito importante dentro desse programa, que é o papel de servir de hub, como um elemento em que vários atores do processo se conectam, coordenados por estratégias dirigidas e planejadas pela instituição eleitoral, e a partir daí conseguir dois impactos muito importantes. Primeiro, ampliar o alcance da sua comunicação institucional. Então, já que a lógica do enfrentamento se baseia no enfrentamento da desinformação com informação qualidade, informação acessível e informação técnica e apurável, a gente vai precisar, então, ampliar o alcance dessa informação e, nesse sentido, a posição dos associados, dos parceiros, que são diversas instituições que fazem parte desse núcleo de combate à desinformação, que foi capitaneado pelo Tribunal Eleitoral Brasileiro. Eles tiveram um papel muito importante, porque com isso se conseguiu tanto reduzir alguns aspectos negativos, como, por exemplo, dentre as várias narrativas que foram trazidas pelo professor Frederico, podemos encontrar algumas delas que estejam tendo mais impacto em determinado momento, e a partir daí os parceiros reforçarem suas estratégias de combate focadas nessas narrativas, mas também de fortalecer alguns aspectos positivos, como a divulgação de realização, por exemplo, de teste de urna, teste de integridade. Isso reforça a confiança no processo, isso pode ser amplificado por meio da atuação dos parceiros. Um segundo ponto, que também é bastante relevante, é essa busca por uma heterossertificação. Sabemos que uma atuação da Justiça Eleitoral, quando defende o seu processo eleitoral como um todo, ele tem uma capacidade de alcance que ela é menor, claro, justamente por sua contaminação, porque tem interesse direto. Então, a atuação de parceiros, eles conseguem transferir essa autoridade. Então, a gente tem aqui uma autoridade dos parceiros, desses associados, como um ativo que é compartilhável. Então, a gente pode ter uma instituição de ensino, de pesquisa, que desenvolve pesquisa e analisa, que bate as informações que foram encontradas na pesquisa com aquelas que são divulgadas pelo organismo eleitoral, de forma que esse discurso ele consegue ser reforçado. Além disso, a gente costuma ter também com essas instituições uma presunção de objetividade, que a gente afasta um pouco disso quando a gente fala do próprio órgão defendendo o seu processo. Então, também de forma muito objetiva, o professor Rafa já adiantou que existem alguns eixos de atuação. O primeiro deles é o eixo de informação. Aqui, a gente observou na Justiça Eleitoral um ânimo no sentido de produzir e difundir informação veraz, de qualidade e oficial. Nesse sentido, foi desenvolvida uma ferramenta em parceria com a Meta, chamada de chatbot. Esse chatbot, ele serve como um mecanismo de transferência de informação, então qualquer pessoa pode ter acesso pelo seu WhatsApp, e o WhatsApp está presente em 99% dos telefones brasileiros, então a informação está na mão de todas as pessoas, que elas podem ter acesso, simplesmente sem custo, transferindo e perguntando ao TSE, buscando informações por meio desse chatbot. Esse mecanismo teve grande êxito e se consolidou como o maior chatbot do WhatsApp no mundo. No segundo eixo de atuação, a gente fala então no empoderamento, garantia que a população comece a entender como funciona essa engenharia da desinformação e se torne, assim, mais resiliente aos impactos da desinformação. Temos aqui, então, algumas ações que foram desenvolvidas pela Justiça Eleitoral Brasileira com a ajuda dos seus parceiros. Um exemplo deles foi o que se criou lá, conhecido como pílulas contra a desinformação, chamam pastilhas contra a desinformação, que fazia parte de um contexto de pílulas contra a democracia, partindo da ideia de que as informações têm que ser muito curtas, porque a população, por vezes, não recebe informações muito longas. Então, durante 30 dias, cada dia tinha um tweet da Justiça Eleitoral, que foi nas suas redes sociais, que servia como uma pastilha diária para ajudar a desenvolver a resiliência da população. Isso foi desenvolvido com alguns pesquisadores. Por fim, no terceiro eixo de atuação, encontra-se o eixo de resposta, que é justamente a adoção de medidas mais objetivas para identificar, e então a gente pode falar aqui no monitoramento, para conter e para desincentivar práticas desinformativas. Nesse ponto, um mecanismo de destaque foi desenvolvido, chamado Sistema de Alerta contra a Desinformação, que ele tem alguma complexidade, mas de forma simples a gente pode entendê-lo como um canal, a utilização de um canal extrajudicial que foi desenvolvido com todas as plataformas. O Tribunal brasileiro, ele possui associação, que são 13 plataformas, e a partir dele conseguiu-se obter dados sobre a desinformação e enviar também para as plataformas informações, flags sobre desinformação para tentar buscar redução do impacto no ecossistema informativo. Então, aqui, para encerrar de forma bem pontual, trago aqui alguns dados que foram divulgados pelo Tribunal Brasileiro quanto aos resultados de atuação. Foram obtidos 160 instituições associadas ao programa, e a gente encontra aqui partidos políticos, plataformas, universidades, organizações sociais. Todas as plataformas se uniram ao programa, e também há várias atuações muito importantes, como algumas eu já destaquei. E, por fim, o último ponto que a gente traz é a associação com agências de verificação de fatos, que atuaram de forma absolutamente independente, mas trazendo mais informação, trazendo mais transparência ao processo. Então, eu encerro aqui a minha fala, para a gente tentar conseguir ainda alguma ou duas perguntas ainda, já considerando que o tempo está... A gente consegue mais duas? Mais uma ou duas perguntas para a gente encerrar aqui o nosso... que já vai ter uma próxima plenária, né? Obrigado, então. Por favor.
Ay, es que si no, no se graba. ¿Quién tiene el micrófono? Te llega, pero perdona, Adriana, pero es que...
Eu falava,
Cuidado que pesa um montão.
Tá. Eu falava que tem muita população fora do circuito informativo. Como é que fizeram com as pessoas que não têm contato com a imprensa ou com as redes sociais?
Obrigado. Quem gostaria de responder?
Bom, a desinformação ela é um fenômeno tecnológico. Ela corre basicamente dentro das redes sociais. No entanto, quando a gente trata de confiança nas eleições, a gente está falando de uma manifestação de opinião pública. E a opinião pública se forma também em outros espaços. Basicamente, portanto, embora a desinformação seja um fenômeno online, a construção de confiança tem que acontecer de modo analógico e também offline. Para isso, a Justiça Eleitoral Brasileira tem um programa de comunicação que envolve a difusão de pautas democráticas e de construção de confiança através do seu corpo funcional, que é multitudinário e capilarizado em todo o país. Foi criada uma Frente Nacional de Enfrentamento à Desinformação, com mais de 2.100 voluntários, e essa Frente Nacional, em primeiro lugar, ela realizou diversos eventos com esclarecimentos de pontos essenciais de desinformação em todos os estados do país, inclusive, especialmente de forma interiorizada. Além disso, esses mais de 2.100 voluntários têm contato com cerca de 2 milhões de cidadãos que trabalham como funcionários das mesas eleitorais, o que nós chamamos de mesários. E, portanto, foi criada também uma forma de comunicação a partir da qual as nossas campanhas publicitárias e peças de esclarecimentos vertiam rapidamente, em poucos segundos, para milhões e milhões de pessoas. Além disso, dentro do programa de fortalecimento institucional, a Justiça Eleitoral brasileira tem uma diretriz de estabelecer alianças com stakeholders. E ao buscar esses stakeholders, a gente alia instituições que têm expertise com instituições que têm capilaridade. E, portanto, a gente tem um desenvolvimento de conhecimento, de um lado, que é vertido, espraiado por toda a população através desses braços, como, por exemplo, a Ordem dos Advogados do Brasil, né? Eles foram fomentados em todas as cidades do país a celebrar eventos em nível local com as comunidades, tratando da transparência, da integridade das eleições, da segurança do processo eletrônico. E também, fora do ambiente offline, também se trabalhou para que as peças de comunicação, fora do ambiente online, trabalhou-se também para envolver as mídias locais, porque embora a população brasileira não tenha muito acesso e não tenha muito interesse em acessar as redes sociais da Justiça Eleitoral, as rádios, sobretudo em nível local, são acompanhadas por toda a população. Então as rádios locais também foram envolvidas e, para esse fim, o TSE tem uma rede de contatos aí que tem mais de 6.000 emissoras em todas as localidades do país.
Além disso, a Justiça Eleitoral conta com a rede de tribunais eleitorais, são basicamente 27 tribunais eleitorais, em todos eles, do ponto de vista da educação para a cidadania, existem escolas judiciárias eleitorais com uma capilaridade impressionante. Essas escolas, nas diversas regiões do país, contam com parcerias com escolas públicas municipais, com escolas públicas particulares, com inserções de grande impacto, por exemplo, com a Unicef. Então, a capilaridade ainda offline ocorre também por via da educação para a cidadania, por intermédio das escolas judiciárias eleitorais.
Eu queria apenas acrescentar um ponto que diz respeito, inclusive, à minha fala, que é uma iniciativa que foi adotada com um stakeholder também, que veio trazer essa busca por informação. A gente, como a senhora bem falou, existe um déficit de informação, de acesso à informação no Brasil, mas a gente também tem um uso muito grande de telefone celular no Brasil. Existe um uso que é altíssimo e 99% dos telefones nós temos WhatsApp. Então, no Brasil conseguiu se desenvolver um acordo com as empresas de telefonia. Qual é a dificuldade? Existe no Brasil um uso muito comum, boa parte dos telefones, eles têm crédito. Não sei se me faço claro. Então, você tem que comprar o crédito para poder ter acesso. Muitas pessoas têm acesso a crédito muito limitado e as empresas de telefonia dão acesso gratuito a plataformas sociais. Então, considerando que as plataformas sociais têm servido para a desinformação, o acesso à desinformação é gratuito, mas quando ela buscava informação oficial, esse acesso era custoso. Então a gente tinha um custo maior de acesso à informação. O que é que foi conseguido nessa iniciativa desenvolvida pela Corte Brasileira? Essa parceria permitiu que a página de informações da Justiça Eleitoral também podia ser acessada de forma gratuita, então sem gasto de crédito, buscando aqui equilibrar a desinformação com a informação de qualidade. Então me parece uma iniciativa bem interessante para buscar essa solução. Obrigado. Por favor.
Gracias. Una pregunta. ¿Qué consecuencias hubo en la parte postelectoral a aquellos actores que fueron claros y evidentes que participaron en la desinformación a la elección de Brasil? Es decir, ¿hubo alguna investigación? ¿Se están generando medidas legales? Particularmente, obviamente, me refiero a la campaña y al equipo de Bolsonaro, que directamente estuvo atacando al sistema electoral brasileño. Porque esa parte ya no supimos a partir de darle seguimiento a la elección. Gracias.
Talvez Ana, para não comprometer.
Alguém gostaria?
Pode. Quer falar, não?
Bueno, a ver, nosotros estamos trabajando con un Estado de Derecho y por lo tanto algunas preferencias jurídicas toman su tiempo. Hay el contradictorio, hay las demandas formales, bueno, y hay obviamente los hechos que están siendo investigados. El equipo de Bolsonaro específicamente, en este momento, responde a un conjunto bastante importante de demandas judiciales, no solo en la justicia electoral, sino también en otras esferas como la criminal, porque después de todo lo que pasó en el 8 de enero, se descubrieron otros hechos bastante inquietantes, para decir, que conlleva a un cuadro de un intento de golpe de Estado. Por lo tanto, en este momento las instituciones están investigando, reuniendo todas las pruebas necesarias y además dándoles su derecho básico de defensa. Eso va a tomar cierto tiempo, sin embargo, yo como jurista, como operadora del derecho, entiendo que las instituciones sí están actuando. Sin embargo, estamos hablando de muchas demandas, de muchos frentes que no solo abarcan el derecho penal, sino también el derecho electoral. Nosotros en Brasil tenemos muy desarrollado el derecho electoral. Y también no solo los agentes políticos, sino también las personas que adherieron a algunas estrategias, como por ejemplo la invasión del Congreso Nacional y de la sede del Supremo Tribunal Federal. Todas esas personas están respondiendo criminalmente por sus actos. Yo no estoy acompañando estos casos específicamente, sin embargo, acompañamos bastante de cerca lo que la justicia electoral está haciendo con Bolsonaro y sus cómplices, por así decir. Y a mí me parece que todo tiene su tiempo porque estamos en un marco de Estado de Derecho, pero sí están pasando cosas que me parece que serán marcos de uma responsabilidade maior.
Muito obrigado, professora. Considerando adiantado da hora, eu peço desculpas que a gente não vai poder continuar nas perguntas, seria muito proveitoso, mas acredito que poderemos continuar, inclusive perguntas lá na sequência do evento. Então agradeço muito a participação de todos que participaram, ouvindo e também participando aqui conosco. Muito obrigado.
Sarah is going to be here. No.
Good afternoon and welcome to the panel on technology, democracy and elections. I would like to start by thanking el Centro de Estudios Políticos y Constitucionales for provided us with a space for this debate, where we will have the opportunity to listen to 4 top-level experts in their fields. The fact that the panel is entirely composed by women is something that I'm pleased about it, as it brings value and visibility to the research work and effort of these 4 highly valuable academics. Thank you very much. Next, I will make a brief introduction for each of them, and then I give the floor for the presentation in the order in which they appear in the program. So I was thinking in about 10-15 minutes. It's okay? Thank you very much. So after that, if we can, we will make a little bit debate. So in first place, I want to present to Katerina Pavel. Is a professor of public law and international law in the University of Economic and Business Administration in Vienna since March 2020. She has, she was also the Dean of the Faculty of Law at the University of Linz from 2015-2019, and Pavel has held various positions as a research assistant and professor at the universities in Austria and Germany. She has received numerous awards for her work, including the Leopold Klunskat Prize.
It's very Austrian,
Congratulations. And the Cardinal Initzer Advanced Prize. She is also a member of various advisory committees and has published several works in the field of law. So, Professor Pavel, you have the floor. Thank you very much.
Thank you very much, and it's a pleasure and a great honor to sit on this women's panel today. In my intervention today, I will focus on the risk of foreign influence on the election process. There are several ways and means to exert an influence on the election process from abroad. We can identify political campaigning, be it open or hidden, be it direct from abroad or indirect by local actors, or be it via media from abroad. We can identify financing of political parties from abroad, which is another type of foreign influence. Turning to the topic of the conference, cybersecurity and election, different types of the online proliferation of manipulative content, disinformation, misinformation, malinformation, are significant instruments to gain influence on the electoral process. There are several strategies that can be identified, and I'm not a specialist to explain the technical background. And they are, for example, addressing voters by personalized political advertisement for malicious purposes. It's called micro-targeting. It's impersonation. For example, spreading disinformation, spreading deep fakes, for example, sharing of fake compromising private material. For example, hack and leak, or fueling polarization based on real or selected or manipulated information. With the possibilities of the internet, the situation of election campaigns which was confined to the territories where the elections were taking place, have been radically changed. Accordingly, manipulative content, which can have harmful impact on the democratic process, can easily cross borders and be foreign influence. Furthermore, foreign influence on the electoral process can be exerted by cyber attacks on the electoral infrastructure. When talking about foreign influence on the electoral process, it is necessary to look closer at the author, the creator of the manipulative content or the presumptive cyber attack. We can make a distinction between a foreign state and the foreign private actors. We all know that private actors, especially internet providers, have taken up the gatekeeper role. Those private actors play a crucial role in the dissemination of information and ideas, and negatively of disinformation as well. As their place of business can be anywhere, they usually act as foreigners. We all know that it's challenging to hold those private actors accountable for dissemination of manipulative content, which affects the electoral process, and we discussed it before. A specific threat to the electoral process results from influence by foreign states. When referring to foreign states, it is not only the state itself and the state authorities which can be the creators of manipulative content, aiming at influencing the electoral process in another state. In addition, political groups, media, and other stakeholders dependent on the state can be the authors. In practice, it is really difficult to find a clear distinction between non-state actors and actors that are structurally dependent on a state or have interests very close to the state and are associated with it. What can be the reasons for foreign states to interfere with the electoral process of another country? One reason could be to take sides with one or another political party or movement because of own political interests. Another reason could be to foster a polarization in the state by way of targeted disinformation campaign. Furthermore, by technical obstruction of the electoral infrastructure, a foreign state could aim at weakening the trust of the citizens in the election, the trust in the democratic legitimacy of the candidates, in the rule of law, or in the domestic structure system of the state as a whole. Altogether, foreign influence on the electoral process of another state usually aims at weakening the state and gaining more influence, more foreign influence. On the one side, the problem and the challenge of these online strategies to undermine the electoral process in a state that, is that they are hidden, not transparent, and cannot be detected by the voters. Once the suspicion is raised that a foreign power is influencing the electoral campaign or the technical electoral infrastructure, the mistrust has been generated. The loss of trust in the electoral process is a fact that is very hard to overcome. Just the rumor that there could be such can lead to mistrust. On the other side, it is said that in the case of foreign influence on the electoral process, I quote, overt interventions are more effective as covert interventions, as interventions by global powers usually significantly increase the electoral chances of the aided candidate. I think both effects go hand in hand and mutually influence each other. They lead to an overall atmosphere of uncertainty and mistrust in the electoral phase of a state, which can be a threat to democracy. From the perspective of international law, the targeted influence of a foreign state on the electoral process of another state may interfere with the right to each state of self-determination of internal affairs, which constitutes one essential element of the principle of sovereignty. And I'm looking very much forward to discuss it in the respective roundtable this afternoon. This legal qualification is important, but it does not offer concrete options to counteract foreign influence on the electoral process. In legal terms, it is unlikely that a foreign state can be held accountable for spreading the disinformation. In my view, it is questionable whether legal options are appropriate and effective instruments to overcome. And I hope to discuss this later if you see any other options. Thank you very much.
Thank you, Professor Pavel. Now, Tiffany Roblot. Tiffany Roblot is the Senior Legal and Justice Advisor for the International Foundation for the Electoral System. She is an expert in law reform, regulatory development, and resolution of sensitive political and electoral disputes. She has worked across programs for more than a decade, with a long-term mission in Afghanistan, Myanmar, Kosovo, Nepal, yes. She has conducted a research and design projects on alternative dispute resolution mechanisms, case management system, and effective investigation for political and electoral disputes. Tiffany has 2 Master of Law degrees and now is admitted to the New York Bar. So, Professor Roblot, you have the floor. Thank you very much.
Thank you very much. It's a great honor to be on this panel with my co-panelist. The presentation focused here on the impact of the use of election technology on the election dispute resolution process. So slightly different than my first co-panelist. But we, at IFES last year, we spent sometimes looking at case law of how courts handled election dispute resolution proceedings relating to use of technology. So as Katie mentioned this morning, we've developed an election judgment database that provides a range of cases, including the use of technology. So I won't go into details because there's an actual paper presenting those case studies, but I'm going to present today just the main findings, challenges, and recommendations. So many have hoped that technology would revolutionize how elections are conducted, moving away from traditional paper-based approach to ensure faster and easier voting, as well as higher accuracy. But some elections recently, and also of course in the US, but also recently Nigeria, have brought some issues regarding vulnerability to failure and security breaches, as well as misperception and suspicion over the election technology used. So we've, in addition to looking at how the courts have handled those cases, we've also held some discussion with election judges in different countries, as well as with practitioners. And with the rising role of the courts handling election petitions, we've seen the need to reinforce the information about election technology for the judiciary, and not necessarily just judges, but also the clerks or the registrar who are sometimes handling those auditing of the election technology. In some countries where IFES work, technology is very new. Like Albania introduced it recently, Georgia is introducing it, North Macedonia as well. So this is still issues that haven't been brought to the courts. So we found that it's an interesting debate and opportunity for exchange with countries that have dealt with those litigation already, like in the US or in Kenya, Malawi as well. So some of the preliminary finding is, of course, we looked at the applicable standards. And my co-panelist Adita is going to go through the standards and that we have regionally. However, globally, there's no applicable specific standards on election technology. So I look forward to hearing more about those standards for Europe region. But we've seen that, of course, general principles on election, like secrecy of the vote, integrity, transparency, will apply to the election technology. But we've seen that those litigation of election technology cases are putting sometimes in jeopardy some of the key election dispute resolution standards, such as the importance of an effective, prompt, and timely investigation. Some cases have revealed that it's hard sometimes for the party agents or the candidates to have access to the evidence, because if you want to challenge the technology, you need to look at the servers, you need to have access to the database or like the coding and things that are not necessarily easy to get those evidence. So for instance, in the Kenya case that we looked into from 2017, when the Supreme Court canceled the elections due to the lack of security and transparency and verifiability of the results management system, they also shifted the burden of proof during the case because there was also this challenge for the parties to get access and really look into what happened to the results management system during the hearing process. Another challenge is, of course, the effective, proportionate, and timely remedy. Some cases, for instance, we looked into an old cases of the Federal Constitutional Court in Germany, who basically took 5 years to adjudicate on a case relating to election voting system. I mean, looking at the public scrutiny and the importance of transparency. But of course, the judgment was issued, I think, right before an election, like the next election. And in other cases, in Kenya, they give the election management body the law provides that it's 60 days to hold a new election, and with recommendation to change some of the element of the results management system, which, of course, election officials know it takes a lot of time. It requires a pilot. It requires time to test and build confidence in the system. So sometimes there is also this issue of judgment that comes that do not necessarily leave enough time for the election official to implement. And so the importance of finding effective remedy. Another issue is, of course, the auditing of a technology. And some election judges are faced with extremely tight deadlines. Like in some countries in Europe, they have 3 days to adjudicate cases. In other countries, they have 7, 15, 21 days. And to hold a complete audit on a technology, I think talking to ICT expert, who I am not at all an ICT expert, but talking to some of my colleagues, it does take a lot of time to look at the servers and whether there was integrity breaches, security breaches, who had access to the servers, looking at the logs, etc. So, and it requires the court itself sometimes to have identified good ICT experts as well. So those are like some of the challenges that those cases have highlighted. Another one was also a challenge of data protection and privacy, and EMBs are usually handling those data privacy with the voter list, with collection of information. But then when those cases are being challenged in court, there's a potential risk that because it's become evidence and this is reviewed during the hearing, that maybe courts sometimes in some countries may not think about this high level of data privacy that needs to be ensured, that the information about the voters are not suddenly disclosed in a public hearing. Another challenge is also, of course, the transparency with the rising mistrust. And I think a lot of courts now are strengthening their transparency in their hearing. But when there is a hearing on election dispute resolution, election dispute regarding technology, there's, I guess, like an enhanced maybe need to open it and make sure that people can follow what's happening to build that trust. And Kenya Supreme Court, for instance, in 2022, did a live streaming. In Ghana, when they did like also some full recount, they also open it fully for like media and observers to also be able to observe those proceedings, which is definitely good practice to think about when litigating those cases. So again, the paper, and we're happy to share it, to share the link of the lessons learned of all those cases that we looked at. We extracted a few suggestions or recommendations from those experiences. And one of them is the importance of auditability. So the importance of EMB to ensure that they have this evidence ready to share in case it is challenged with the courts. And this is something that just also came up in the Nigerian election, where suddenly there's like so much digital evidence, and on both sides, like the EMB needs to be ready to hand it over for potential challenge, but also the court needs to be ready to process it and look at it and record it to be able to use it and review it in a quick manner. It is also important for the EMB to keep control of its technology in terms of access and passwords, and so that they keep that even if they have service providers helping them with developing, designing the technology, so that again, if there is a litigation, they can quickly share the evidence and make it accessible for review by the court. Another element that we found based on our discussion with election judges when handling this case is the importance of interinstitutional cooperation, so that the judges and the clerks have also a good understanding of what the technology is. And in Kenya, we had the great privilege to work with election judges there and with the EMB, and we held those discussion workshops with the registrar of the Supreme Court and the EMB well ahead of the election, so that they can talk about, okay, what is your results management system? How does the system work? Like, where does it go? And review their templates for audits and scrutiny of the technology, so that they really had a good understanding of what the technology is in case it was later challenged in court. And we saw the results of that in the 2022 election petition process, where the coordination between the two, the sharing of evidence was smoother. The registrar knew what to look into, what type of evidence to collect in advance, because they had this cooperation. And of course, it's important to ensure this cooperation ahead of time, so you don't create perception of collusion between the EMB and the election court. But that's, I think, was an interesting cooperation element to think about, I think, for other places where technology is introduced. And then lastly, it's looking at judicial procedure. And in some countries, there's still a need to adapt the rules of procedure of the court to be able to access and look into those digital evidence in a timely manner, and also maybe create more provision for this enhanced cooperation ahead of time with the EMB secretariat, usually, who can help collect all this evidence. So again, the paper is available on this election judgment database, and it does provide like a series of judgment. You can look here and pick up like the topic you want to look at, so it's not just election technology. And it also includes a lot of election dispute resolution resources from other countries, like the compendium from Kenya, election court is there, Malawi, Tanzania. We have also a lot of Council of Europe recommendations and guidelines as well. So I invite you to look at it when you have time, if you're interested in this topic. Thank you very much.
Thank you very much, Professor Rowlott. Now, is the floor of Sarah Bender, has received her Juris Doctor degree from the University of Michigan Law School, and she previously worked as a domestic policy aide in the U.S. Senate. She completed her undergraduate studies in public policy at the Duke University, and she has recently published an article on algorithmic election, the use of artificial intelligence in the US elections. So thank you very much, Sarah, for coming, and you have the floor.
Is it on? Okay, wonderful. Well, it's wonderful to be here. I'll echo my co-panelists. Thanks. It really is an honor to be on this panel and to have been invited to attend and speak at this conference. So thank you all. I'm very excited to present my research, which is on an emerging subset of election technology, namely algorithmic tools and artificial intelligence. Our conversations on over the past few days have focused on foreign and how foreign and political bad actors can disrupt elections, namely through the spread of disinformation. And AI can be a key weapon in the spread of disinformation. So, for example, the Blacktivist campaign that was mentioned by Professor Ravel in the panel this morning, that did leverage AI. AI can be used to create particularly persuasive forms of disinformation like deep fakes. And so this is certainly a way in which AI and algorithmic tools can have an impact on democratic processes in our elections. I'm actually going to be focusing on some slightly different uses of AI. First, the technologies I'll be looking at are those that are being used not by foreign or political bad actors, but rather by the public officials who are running elections. They're adopted typically not with any ill intent, but rather because these officials are looking for ways to make election processes more accurate, more efficient, more accessible. And so in this way, they may seem more innocuous than the AI used in disinformation campaigns. However, they can also have some pretty significant effects on voting rights, voters, and our democracies. The technologies I'll be discussing are already in use in at least some elections, and I'm looking specifically at technologies that are being used in in elections in the United States. So I think it's important to know the U.S. Election system is unique in I'm sure many ways, but one key one relevant to this discussion is our elections are very decentralized. So local and state officials have a very significant amount of responsibility in how elections are run, and specifically in how these types of technologies, whether they're used, how they're used. This has some benefits with regards to being able to kind of experiment with these technologies, but it can also create some real difficulties with regards to regulating the use of these technologies. And in the past, this decentralized system has really allowed suppressive and discriminatory election practices to run rampant in U.S. elections. So here's the clicker. I may actually need to use this. Let's see. Okay, so I'll share just again a few examples of how AI is being used already to administer U.S. elections. I'll flag a few potential concerns briefly regarding these technologies, and finally just share some quick takeaways as folks or for policymakers who are beginning to think about adopting these technologies. Excuse me, just lost my screen. All right, excuse me, go back. Let me go back. Okay, wonderful. So one of the first ways in which AI is being used to administer U.S. elections is to manage voter rolls. So in the United States, states are required to keep a uniform, centralized, statewide voter registration list. And this voter registration list must be updated to keep ineligible voters off the registration list and also to add newly registered voters to them. This practice of removing voters is commonly referred to as voter purging, and it can happen for a variety of reasons, including changes in residence, felony convictions, and death or otherwise voter inactivity. Voter purges are usually at least partially automated. The automation is not itself a novelty. However, algorithmic tools are increasingly being used to overcome some common challenges with regards to voter purging and voter maintenance. The first is name matching. So sometimes across the different databases that individuals reference to learn whether a voter may have died or may have moved, the names may be listed slightly differently. So John X. Jones may actually be listed as John Jones in the driver's license records. And so AI is often used to kind of compare those records and determine whether voters are actually the same. Another use is with regards to interstate moves. So as I mentioned, the registries in the United States are managed by each of the different 50 states. And states are responsible for managing themselves and coordinating amongst themselves to determine when voters move between states and to update their records accordingly. There are some new initiatives that have been used, again, leveraging algorithmic tools to kind of collaborate between states and keep those records up to date when individuals do move between states. Ironically, the current kind of program, ERIC is the acronym for it. That program is actually right now itself subject to some disinformation around its purposes and how it's being operated. So it kind of remains to be seen the future of this program, but it has been used and does leverage algorithmic technologies to facilitate these checks. These technologies certainly make election officials' lives easier, but they can also render biased and inaccurate results. So for example, at least one study has shown that name matching algorithms render more mismatches for voters with names of Asian descent. Similarly, interstate cross-checking technologies have been found to yield a higher number of false positive results among minority voters. And these inaccuracies are not insignificant. They lead to eligible voters being taken off voter rolls and then not being able to vote at the next election. These technologies can also be misused, so they may be perfectly accurate and trained well, but election officials may use them to reference databases that have nothing to do with whether the voter was actually eligible. So for example, in the past, election officials have purged records based on the fact that certain names were in an immigration database, kind of based on the assumption that that database indicated that they were a non-citizen, but these were actually recently naturalized individuals who were in fact eligible voters. The next use is with regards to signature matching. So more and more voters are voting by mail in the US, and most states that allow vote by mail require these ballots to be signed by the voter and for these signatures to then be validated. This is usually done by comparing the signature on the ballot with another one in the voter file, which typically comes from, the signature you give to get your driver's license. Verifying these signatures is very time consuming, and so it's no surprise that jurisdictions have been very excited by new AI that does this verification for them. So these AI evaluate certain features of the signatures just like an individual would and determine whether or not kind of flag possible mismatches. Like the first category of AIs I discussed, these technologies can be extremely helpful. They, again, automate and ideally kind of eliminate some human error that can happen with signature matching. But again, are often, there's reason to think that they may be biased and have more inaccurate results for certain voters. So the AI that many jurisdictions are using are trained only on signature, kind of English-only handwriting. And so it seems likely that for voters in the United States who have non-English, non-typical English names, that these may render more inaccurate results for this group of voters. There's also reason to think that they'd be more inaccurate for individuals with disabilities, older voters, younger voters, where they may be less represented in the data sets used to train these AI. And again, these are significant results, have a significant effect on voting rights, because when a ballot is flagged as a mismatch, there are a number of states that do not require these voters to even be notified of the fact that their ballot is going to be thrown out. So generally, these voters, their vote is nullified. The third and final example I'll give is with regards to redistricting. So many key elections in the United States are district elections. These district lines have to be redrawn regularly, and the process of doing so in the United States is a very partisan one. It is typically handled by various public officials. Again, this varies a lot by jurisdiction. But it is routinely manipulated, as was mentioned in the earlier panel, to favor certain political parties or protect an incumbent candidate. This practice is referred to as gerrymandering, so I may use that term. U.S. courts have long struggled with how to adjudicate gerrymandering claims, as was again mentioned this morning. AI has actually been proffered as a way to kind of give courts a baseline for what a fair map might look like. However, the United States Supreme Court has declined to kind of embrace these technologies in its adjudication of these cases, and rather has kind of moved towards eliminating many of the legal barriers that exist to adjudicating gerrymandering claims. At the same time that these legal barriers have been reduced, partisan gerrymandering has become more and more sophisticated because of the use of advanced analytics and now AI. So rather than just making educated guesses about which types of maps might favor a political party, officials now have access to very, very comprehensive voter data sets and these advanced analytics that allow them to draw millions of maps and then pick the one that most insulates their party. So again, redistricting AIs, they are even more advanced in some of the technologies that have been used in recent elections, can pick up on even more patterns and really predict voting behavior on a very individual level. And again, another kind of key point with all of these is, and I think this was mentioned by my co-panelists, these technologies are very difficult to audit. Their reasoning and how they operate is very opaque. And so understanding how these AIs are drawing maps, determining whether they may be doing so based on the voter's race or other protected characteristic, it's very, very difficult to do so. And so not only are these creating more sophisticated gerrymanders, it also makes it very difficult to crack down on them. So I'll close. So again, we should absolutely be addressing the bad AI that are fueling disinformation campaigns and being used to disrupt elections by bad actors. But it's also important to remember that these good election AI can cause harm. And so while they do have many benefits, we need to be thinking about them carefully and with a lot of scrutiny. So again, just to recap, these technologies are not perfect. They may render inaccurate and biased results. They may also be unintentionally misused, but from using the AIs in ways that they were not designed to be used, or by falling prey to automation bias and over-relying on these technologies because we think that they're better at doing things than we are. We should also remember that these technologies, even ones that were designed for good purposes, can be intentionally misused. So political pressures can incentivize individuals to potentially abuse these technologies. And finally, again, the lack of transparency means that it can be very difficult to tell when this type of misuse is happening, even with these otherwise benign technologies. So I'll just close with a few, again, kind of recommendations for as we think about how to conduct oversight of these technologies. It's certainly needed, but it must be ongoing. It can't just be about whether a technology is good enough to use it. We need to be looking at how they are being used on the ground. And this oversight also needs to be tailored to each election system. thank you again for having me today. Please feel free. This research was recently published, and I'm happy to share it, and also to take any questions now or later.
Thank you very much. Thank you very much, Sarah. Now, Ardita Adriza Mauer. Ardita is an independent legal consultant, and she works in the field of election with a focus on the use of digital solutions. Ardita leads a group of experts of the Council of Europe and the Committee of the Experts on Democracy and Good Digital Governance. And they produced on 2022 guidance on the use of the ECT in elections. So, Ardita, is your floor. Thank you very much.
Thank you very much, Liris, and thanks for having me. I am conscious I am in between you, you and the lunch. So, how many minutes do I have?
10.
10. Okay, good. And then I'd be happy to take questions also during lunch or afterwards. Okay, so let me first just put this into the context. So we have been talking so far mainly about disinformation, misinformation, and social media and artificial intelligence. All these processes mainly concern one electoral phase. As you know, elections are processes that have different phases, and they are being repeated. We call it an electoral cycle, which takes place during each election and is repeated for the next ones. So social media and the other elements we have discussed today, they are focusing mainly on one specific phase of the electoral cycle, which is opinion formation. Of course, their effect spills over all the other phases, but the aim is to have voters make an opinion and express it during the vote. And that's what social media focuses on. But as you see, there are all these other phases of an electoral cycle, and ICT has been used and is increasingly being used and introduced during all these other phases. So the question here is mainly a question for the EMBs, but it is, of course, it's a question for lawyers, for judges, and for the whole system, democratic system. The question is, how do we build ICT that is in compliance with principles for democratic elections? And of course, the question cannot be answered very easily because ICT brings a number of paradigm changes to the way EMBs organize their work. So, in this context, the Council of Europe has been dealing with regulation of ICT solutions that are being used in all these other phases of an electoral cycle. Of course, the Venice Commission has also been working on social media, misinformation, disinformation, but that's just one part. The documents I'll talk about now, they address use of ICT throughout these other phases. Theoretically, these solutions should be controlled and introduced and supervised by EMBs. So EMBs should have the upper hand, should be able to control such solutions, as opposed to social media, where EMBs do not have such oversight and such power. However, it is not easy for EMBs to address these other solutions either, as we also heard earlier. And just to make the link between disinformation and these other ICT solutions, we talked about disinformation done for political reasons, but disinformation flourishes also because it refers to a context, which is the context of use of ICT, which is quite complex and not very well understood by the different stakeholders. Okay, so Council of Europe has introduced mainly two soft law documents. The first one, chronologically, the first one was about e-voting. So already at the beginning of the years 2000, EMBs, because this is a very much EMBs-driven process, EMBs thought we now need to have some guidelines how to regulate use of e-voting, because that was their priority then. And then later, we worked on use of ICT throughout all other processes, so registration, education, result management, dispute resolution, etc., because ICT is being very much used in these other processes as well. So I had the pleasure to coordinate and to lead these two documents. So we try to have, at the end of the day, two documents which are quite consistent with each other. They do not contradict each other. Good. So very quickly, I'm not going through these two documents. There are the first one contains 49 standards, the second one 12 guidelines, so it's too much. I'll just highlight a few challenges which are common to all uses of ICT throughout these processes. So the first preoccupation of these two documents and the main challenge of EMBs is to ensure that ICT is aligned with principles. But what does that mean? That's easy to say in theory and difficult to implement in practice. So first of all, the recommendation of the Council of Europe is to EMBs and also to judges, identify the applicable principles. These are not only international ones, these are national ones as well, and even local ones. And so the first step is to correctly identify them. And then an important question, how to deal with contradictory principles. We have a number of them in the electoral realm, so we have secrecy and transparency, which contradict each other. And this is a decision mainly to be taken by the legislator and the regulator. Very often it is left to EMBs or to providers, which is worse. So here the main point is that you should think about this beforehand and take an informed decision. And have a detailed regulation. Detailed regulation is very important at the end for the EMB to ensure supervision of the solution. And it is, it should be clear, but it is not. Regulation should come before the solution. Very often these processes are provider-driven, and they should not. They should be EMB and public interest-driven. Second, a point which is maybe a little bit technical, I'll try to make it clear. There is no 100% security. This is a paradigm change in elections, because although we don't have 100% security for manual and paper-based processes either, we still have a possibility to check, to have a chain of control from the beginning to the end of the process. And this we don't have, we don't see what's in the ICT solution. So we should understand, EMBs should understand from the beginning that all these, the security of all these solutions is based on assumptions. Mm-hmm. And it is important that these assumptions are being made clear. And this is for the provider to make them clear. EMBs should ask that these assumptions are made clear. Security, for instance, is based on the assumption that the verification processes will effectively be used by the user. But will the user actually use verification processes? Is the user aware of his or her own importance in securing the system? This is not true, and usable security is a huge research field, and there is still a lot of work to be done there, so no solution is perfect, and EMBs should keep these in mind. A lot of other things, but I'll skip. Evaluation, ICT evaluation risk management. So there are a number of evaluations to be done before the solution is introduced, namely evaluation of security, usability, accessibility, but also during the whole period when the solution is being used. And this is mainly linked to risk management. And Also, these should be done taking into account the assumptions that we talked about earlier. And there are some new questions. ICT will never be 100% secure. Even, if you have done things correctly, there is remaining risk. And this is a new question for the EMB. Who takes the responsibility for the remaining risks, and how practically that will be controlled? Okay, some last word on the challenge that is linked to our understanding of ICT. So ICT solutions, at the end of the day, this is something that comes from the IT community, should be able to provide convincing evidence. So the burden of proof is a little bit changed in this case. It's not for the voter to prove that there was a problem, because very often this is not possible. It's for the solution to offer the proof that it is correct and the results are correct. Okay, this seems very good, and it is very good, but there are still some questions, because the proof in this case as well will be based on mathematics, and people will not understand do not understand the underlying mathematics. So if we think that ICT will eliminate the need for trust and offer us proof, yes, but because still you need to trust the math, still you need to trust the experts. You don't have the expertise to understand that. So, yeah, and again, these questions, the main message is that these questions are so important that they should be discussed by the legislator and the regulator, but not by the EMB alone, because EMBs have a normal tendency, and also given the deadlines, which are very short, to say that everything was perfect, it worked, we have formal proofs. So it's normal, it's human, and hence the importance of having these issues regulated beforehand by the legislator and the regulator. Okay, I'll skip this. Just to sum it up, to summarize the work of the Council of Europe, it has sometimes been referred to as pushing for use of ICT in elections. It's not true. Council of Europe does not push, but Council of Europe is there to make sure that when ICT is used, it should be done in accordance with the main electoral principles and other applicable constitutional principles. This is the main message. And the other one is that ICT raises very complex legal questions. Council of Europe offers a number of answers to that, but there are still other issues which are still work in progress, and countries are working on them as well, Council of Europe and so on. So it's not, we don't have definitive answers to most of them. Well, thank you very much. Sorry.
Thank you very much. And now, thank you, all of them, for the interesting presentation. And now you have the floor if you want to ask the panelists. Rosa?
Okay, Rosa Fernandez from Madrid Complutense University. Thank you very much because all presentation really have been very, very interesting. So I have many questions. I suppose that my questions are a chilling question in terms that no answers to those kind of questions. But I try to focus my question about what happened with the citizens, because well, we have different steps when we are thinking about the long and complex electoral process, the beginning, the middle steps, the final, the manner to treat this potential legal dispute about the result and so on. And we are checking that the manner to build law is very complicated, because we have to put in a dialogue between the legislator and the experts. In the middle, we have to put in context and to get close, not only in a legal field, but also in the electoral process, many stakeholders to try to understand. So my question is focused on the citizens, because remember in the 2009 German Constitutional Court judgment, this electoral process for the German parliament was declared unconstitutional. And one of the most important reasons was that the citizens must understand the electoral process using technology. And we have to think in a normal citizens without a specific knowledge, without a specific ICT abilities, skills, and it is very important to maintain the security, the quality, the safety of the electoral process in general terms, focuses on normal and simple citizens. So my question will be referred to the normal citizens. So thank you.
So wherever you want. Sara, Ardita.
Okay. Please go ahead. Just very quickly, this is a question about the role of experts as well, and the answer has been very different in different countries. So this is one of those issues that has not been decided. You mentioned the decision of the Constitutional Court of Germany. The Constitutional Court of Austria reached a similar decision. And the decision is that that it should be a regulation, at least. They focused on the regulation of these solutions should be as detailed and as clear as it can be understood by, in Austria, the Electoral Commission, and in Germany, all steps should be understood by the individual voter, which is a de facto ban on such use of ICT for the time being, because it is impossible for the... But you have other courts and other places where the role of experts or of certain democratically designed, designated experts has been accepted. This is the case in Switzerland, in Estonia. In the United States, the court has kind of left the responsibility to answer that question to the political branch of power in Switzerland as well. So these are still things that are evolving. Even those countries who have accepted the role of experts, they have still not answered a number of questions. What if experts disagree, for instance, is one of them. So these are still open questions. Yeah.
Thank you very much.
If I may just add on the use of experts, because we see this as well growing, and not just having independent, well, sometimes so-called independent ICT experts joining the proceeding, but also, for instance, in the Kenya case, they joined as friends of the courts. So you had ICT company or like NGO who provided some insight. So more from like the civil society perspective. But it's true that the use of expert also brings another challenge, is that they can be partisan. And in the US cases we've seen recently is that both sides are going to bring their experts. So that's a big challenge for the courts, right? They're going to listen to experts, but then they may be, from one side or the other. In terms of going back to the citizen, I think, Ardita, when you presented the standards, you say it's not because we have technology that it doesn't mean you need to be transparent. You still need to gain that trust. And of course, I think it forces the EMB to be even more transparent with technology because of this mistrust that we see increasing. And the EMB in Kenya, again, to talk about this recent election, they did a lot of public simulation. So they went around the country and they would just showing exactly how the machine is going to work, and invited like everybody, and they encouraged their election officials in specific area, at the local level, to just show them how it's going to work and where it's going to go. And they published those very simple infographic about this is the server and this goes there and then we get it at the central level, etc. So I think there is an effort that needs to be made on this awareness to reassure people of how it's going to work, even if there's no way we all going to become ICT experts. I don't like technology. I'm not good at it. But at least you're reassured that someone is showing you in a simple manner how it works. But that's still a challenge, I think, for EMB to do that.
Yeah, I think this is a significant challenge with AI. I think I might be misremembering the quote, but I read somewhere that like asking even the AIs can't really explain their own reasoning, and so you can show them the server, but the outcome it generates, it's impossible to parse. And so the quote I'm thinking of is, I think it's like asking a turtle how it grew its shell. Like, you're just never going to get the full answer, or an answer that's useful, particularly for, you know, the average voter. And I think that, you know, kind of the response to that, I just saw there was a bill introduced in the United States Congress with regards to how AI are being used in campaigns. And the response, I think the approach that was being proffered was to require disclosure of the fact in campaign that campaign had been created using AI. And I don't know that, I think that might be a fine approach, but it continues to put the burden on the citizen to understand, what does that mean for me? Like, what are the implications of the fact that this was created with AI? And I don't think that most people are going to understand that it means that, you know, this technology had a ton of his or her data and was creating something that was specifically designed to be as persuasive as possible for that individual. And certainly there's some analogs to other forms of technologies and AIs in other parts of the kind of graph you showed. So it's troubling. I don't have a great answer.
Thank you very much, Sarah. Katarina, you want to say anything? No? Some question more? Okay, Loreto.
Yeah, Loreto from Complutense University. Thank you for your presentation. I have a question also regarding the voters' rights, and I am curious about the United States, because I have been living there for a couple of times, and I would like to know if you have any mean regarding how the elder people plus 75 years old or 70, not media literacy people, no? If you really see that there is a gap in terms of lack of literacy, and if there is any mean to foster their participation.
And you said if there's any gap in the lack of what? Yeah. What was it?
Like how they can understand the system, go to the place and see all these huge machines, and how to communicate with them. Because even here in Spain, we don't have that kind of things. But even to use the mail voting system that can be done in advance in Spain, I realize even in my family and relatives how it is complicated, you know.
Yes, I don't know any specific numbers, but I do think that your instinct is absolutely correct, that older voters will have even less of an understanding about what it means for AI to have been a part of some of these decisions. And I think I did mention briefly, some of the biases that these technologies may have may actually be against older voters. So like the signature matching example, older voters who may be more likely to have disabilities, that may make it kind of affect what their signatures look like. Their ballots, when they're cast by mail, may be more likely to be thrown out because of how those biases become embedded in technologies, and again, how these technologies are used and the role of automation bias. So I do think it has an effect both on the kind of these older citizens' ability to understand these machines and technologies in terms of how ballots are being cast. Each jurisdiction has different processes for how to engage with voters who maybe are unable to use the ballot machines. But having volunteered and been on the ground with many of these elections, I know that when an individual with a disability or who is not able to use these technologies does kind of run into those problems, it usually doesn't go smoothly, and their ability to cast a secret ballot is often impaired. So it's certainly those accessibility issues don't go away with these new technologies. I think in many cases, they make it worse.
Tiffany? No? Some question more?
Hi, thank you very much all for the presentation. My question is a little bit general, and it's for Sarah Bender and Professor Ardita. I'm very interested in the voter signature verification that Sarah Bender talked about because of its potential use in the implementation of internet voting. In my opinion, one of the conundrums of internet voting is the verification of the vote once it has been cast without affecting the freedom and secrecy of the right, of that right, especially for cases where there is a breach of the internet network. So my question is whether you consider that handwriting and AI can be implemented in internet voting system precisely to verify the ex post sense of the vote without affecting the rights of the voter.
I'm happy to jump in first. I could imagine it. I certainly think that it could be deployed, and there's likely a way to deploy it well. I mentioned some of the concerns about how the AIs that are being used right now have been designed and the biases that they could lead to. I also think another kind of piece of that is we need to be thinking again about how they are being how they are being used. And so another problem with these technologies right now is the signatures that the ballot signature are being compared to are ones that again, I mentioned they're from when you get your driver's license, and that's using an electric pad. You don't actually, most people when they do that don't know that how I'm signing this right now could lead to my ballot being thrown out. And so it's a little bit haphazard, and I think if we do, increase our reliance on this form of verification, we need to be intentional about it, and we need to communicate to voters what they need to do in order to ensure that they are able to be verified, and I don't think that that's happening right now. So there are a lot of different components that I think go into it. It could be possible, but it needs to be a lot more intentional.
Thank you.
Yeah, very, very shortly. Internet voting is still a research domain, so not yet an established voting method. One of the main challenges is coercion, you're voting from a distant place, so you can be coerced, etc. Of course, you can verify the signature, but if I am under coercion, I will sign, so it's my signature. That does not mean that my vote is free. So there are a number of challenges. I'm not aware. I think there is emerging research about use of handwriting signature. I think I've heard of 1 or 2 papers, but I think this is very, very new. And then again, AI or not AI, we have been using digital manual signatures. Like this is a biometric criteria, and there are a number of, Sarah mentioned then, a number of issues with biometrics, so false positive, false negatives, and so on. Well, maybe AI may improve that, but yeah, so these are, in my opinion, still research fields for further research.
Can I just add? A quick add on the internet voting, because we used it in France for the last legislative election for out-of-country voters. So French people overseas used it, and actually there was a case in 2 constituencies that led to cancellation by the Constitutional Council. It was not linked to the signature, but to validate your vote, you were supposed to receive a code via a text message, and the system didn't work out for I think only 11% of the people requesting the code did get it, and so I think closer to the actual limit deadline, 38% of the people received the code, so it was still a huge number of voters who didn't get it, and even if we actually allow people to vote, at the embassy, at their consulate, but we authorize as well proxy voting. So we have very different method and open this new internet voting for the first time. The Constitutional Court still decided that to cancel those elections because they were trying they kept trying to vote and it didn't work. So they didn't even have the opportunity to then go vote at the consulate or do the proxy voting they could have done for a person who is in France at the time, etc. So new challenges as well about receiving those messages. And as you said, I think it's still a lot of tests, and I think we're going to see more potential litigation on this new method of voting.
Thank you. Some question more? No? So we are on time, Loreto. Congrats. So thank you very much for coming and your presentation, and I hope to see you soon. So thank you very much.
Thank you.